Listed matter, item 46, my lord. My lord, can it be fixed at 2 p.m. or on Monday, my lord?
What has happened?
My lord, rice has been seized, my lord. 8 months already over, my lord. Confiscation order was not passed, my lord. Rice has been seized. Only the allegation of misdeclaration of labeling, my lord. So, my lord.
Very well. We shall see to upgrade it. 46 sector note. Please give a slip with the grounds of urgency.
My lord.
We shall see an upgrade.
My lord. My lord.
To mention one matter for this, my lord. One of the grounds for urgency is that, my lord, the petition is the lady who has been illegally forced out, has been thrown out from her house by the local goons, and she went to the police station to complain, but they are not taking her complaint, and in spite of receiving the complaint, they are not.
Which it's a group 9 matter. Then. I don't have motion determination for group 9.
Motion. I'm mistaken.
My lord, hearing matter. Urgency. He did not get return benefit even after retirement of 17 years in full. A writ application was moved before Honorable Justice Tosma Bhattacharya. He got part credit. Again, another writ application for Honorable Justice, he got part credit.
Yes. देखुन दीदी motion. Yes.
Mention a motion matter regarding serial number 280 of Your Lordship today's complaint. Urgency is Your Lordship that we have received the discovery notice. The tax demand is more than 5%.
Didi.
Can you fix it?
Give notice to the other side that you have mentioned it for upgradation. Give another notice that you have mentioned it for upgradation. It may be taken up.
Your Lordship will be taken up this.
Keep a watch on the list. Maybe Monday or Tuesday. You have mentioned your grounds of urgency.
Yes, sir.
May I kindly mention, my lord, item number 66 of the daily list, my lord. Clients wants to withdraw the safe matter, my lord. I have instruction, if my lord.
66
of today's list, my lord.
Non-prosecution to be mentioned. Non-prosecution. Non-prosecution. Please bring the letters of your client. Please give instructions. Please bring instructions from your client for withdrawal. Please bring instructions for withdrawal so that I can take that on record.
That was discussed, and on the ground that order is available order. The order was of SCM and it is available under section 7 of the Municipal Public Act, edition of Order by Occupants Act 1962. But now, in the meantime, municipal has given a notice to demolish the construction. Now, the appeal is pending to the DM. 1.5 months has been passed by no notice, nothing has been given for the hearing. We have given several notices. We have given.
It will appear on Thursday. Give it. Thursday is the day on which public premises. Thursdays it will be taken up. Thursdays are the days when public premises unauthorized occupants act. Yes. Thursday all matters are taken up on Thursday. Yes.
May I have your lordship kindly to mention a new motion for inclusion?
What about public premises unauthorized occupants act mamla?
Lordship, may I mention virtually one matter?
May I have your lordship kindly to mention a new motion for inclusion?
Yes, please. New motion, please give this list. Yes.
May I have your lordship slip? Under compelling urgency, means a GST hearing matter. My lord, the issue is, my lord, is with regard to refund of ITC. Now, my lord, there were 3 matters filed. My lord, in one, it was remanded back. My lord, we have got the refund. Now, in 2 matters, we are stuck. Now, my lord, the company is.
Why were you stuck? Why did you not?
This matter is not coming up in the list. Affidavits are complete, my lord.
Give it will come in the list.
I'm grateful to you.
Lordship, may I mention one's matter virtually, Lordships?
Give me.
Lordships, may I mention one matter virtually?
Yes.
Lordship, serial 414 I mentioned yesterday, it was for extension of interim order, but it was not come up under extension, Lordships.
কেন দিদি এটা তো উনি মেনশন করেছিলেন কালকে?
Yesterday it was
আমার
399,
মনে আছে
Lordships.
উনি মেনশন করেছিলেন, আমি বলেও ছিলাম ওটা কেন আপগ্রেড করেননি? লিস্টে আছে 40414 কালকে উনি বলেছিলেন ওখানে দাঁড়িয়ে।
Yesterday it was 399, Lordships, for extension of interim order.
এটা তো খুব এম্বারেসিং হয়ে যাচ্ছে না। I say something then it doesn't happen. Why?
Lordship, the last day of the order is valid till 30th of this month, Lordships.
30th means till Sunday.
Till
So
Sunday,
till Sunday
Lordships.
interim order is there. It will appear on
Lordships.
the first as under the heading extension. We'll extend it.
Grateful. As your Lordship.
You give a notice.
As your Lordship. I will give a
Item
notice.
414.
414, Lordship, Geeta Ganesh. My junior is also there.
কাইন্ডলি দিয়ে দিন লিস্টে। আর একবার মেনশন করলেই কিন্তু অসুবিধা হবে।
Grateful to you, Lordships.
Yes, please call the list.
Extension of interim order.
লিখে নিন। This matter is appearing under the heading extension of interim order upon being mentioned therefore full stop paragraph having heard the learned counsel appearing for the respective parties, comma, the subsisting interim order
Delay content
Call
on
next.
technical ground minor. Get.
affidavit has not been filed as yet.
It's been completed actually, Your Lordship, but that's a type error that's crept in. My lord, there's an order, my lord. I apologize. There is a slide. There is an order of 27 June 2024, Your Lordship, which records the affidavits are complete. That was probably inadvertently crept in. We ought to have asked for my rectification. But my lord.
It's not recorded.
My
Affidavit in reply is recorded.
My lord, so my opposition was filed. Thereafter, the reply was filed.
Very well. लिखे नहीं? This matter is appearing under the heading extension of interim order
I'm grateful.
Hearing for extension. The affidavits have been exchanged, Your Lordship. It is ready for hearing matter.
Affidavits are complete.
Affidavits are
Lordship, item 4, it is a prayer for the extension of interim order. My reply to the affidavit in opposition, Lordship, I seek 2 weeks time.
Till very well. প্রথম প্যারাগ্রাফটা ঠিক থাকবে, extended till the end of January যেটা আছে।
Lordship, order dictation has been paused. I am not able to. Lordship, item 5 also in this, Lordships, we are submitting our reply to the counter filed by the respondents.
আচ্ছা, এইটাতে
কপি দিয়েছে
লিখে নিন, এই একই জিনিস সব কটাতে থাকবে, মানে উপরেরটা মিলিয়ে নিন তাহলে। This matter has come up under the heading to be mentioned upon the same being
Lordship has extended the interim order till, Lordships.
end of January.
Grateful,
End of
Lordship. Much obliged.
End
Grateful.
of January.
Grateful, dear Lordships.
My lord, I am appearing for respondent number 1, banking ombudsman.
Yes.
On the petitioners.
It is the matter where at the first instance we did not appear and my junior had stepped up taking my
Yes, she
name.
was there.
Yes, Your Lordship. Your Lordship, before my learned friend begins his case, I would just like to indicate that if Your Lordship looks at when the writ petition was affirmed, it was affirmed on 17th of January 2025, whereas the complaint was closed on 14th of January and communicated on 22nd of January, which
Page,
is not
please
forming
take me to
part.
the page again, ma'am.
Yes, Your Lordship. Lordship will kindly see page number 12, the affidavit, when it was affirmed.
Page 12.
Yes, of the petition.
Page 12, yes.
17th January 2025 is the
Yes.
date of affirmation.
Yes.
Now the complaint was closed on 14th of January and it was communicated on 22nd of January. So naturally, it's not forming part of the records. That's first point. Second of all, Your Lordship, I'm carrying that, in fact, the closure of complaint also. I've got it in hand. If Your Lordship kindly accepts this.
His grievance is that the complaint has been closed unjustifiably.
He complains that there was a telephonic communication of the closure of complaint and that was unjust. My point is the complaint which was lodged, it was taken into account on 16th of December, which is at page number 24. Now, factually speaking, that complaint was lodged after the order of the additional, if Your Lordship kindly sees the order, which is at page number 23A.
Page 23A.
Yes.
Yes.
This is the order of the learned ACJM of Kolani.
Yes.
Now, Your Lordship will kindly take paragraph 3 onwards of the order. On perusal of the same, it appears alleged incident had taken place on 17th March 2024. Information was given to provision of section 154 CRPC. Later on, the matter was informed. Substance of information was sent to Superintendent of Police, etc. Then next paragraph. In view of the above fact and circumstances, it appears that there is sufficient ground for allowing the prayer of the petitioner and evident that the complainant is not in a position to proceed with the case without police help. So initially it was a case of fraud, account fraud, but the OTP was shared, the password was shared by the complainant himself. So there is basically, to begin with, there is no deficiency of service with regard to the regulated entity, which is the bank in this concerned case. A police complaint was lodged, and on the basis of which this order was passed, an FIR was also registered. Now, if Your Lordship looks into the petition once, paragraph 3, page number 3, paragraph 3. Your writ petitioner states that the said unknown mobile caller ring to the petitioner and stated that they are calling from bank authority and stated to give some facilities if your petitioner input his finger to the sending ID, and however on good faith your petitioner given some password to the said person, and suddenly your petitioner noticed that a huge amount of 2 lakh and odd was deducted from the account. Then Your Lordship will see thereafter the proceedings under section 156(3) took place, and then paragraph 5, which is very crucial. Your writ petitioner thought the amount to be recovered as early as possible, but till today, there is no recovery of money and the petitioner have no knowledge whether any proper investigation have been started by the police authority in the meantime or not. And being in such situation, your petitioner have been facing irreparable loss and injury, and he sent a complaint with banking ombudsman. Now, banking ombudsman normally summarily deals with a case under the banking ombudsman scheme. When a complaint is lodged, first it has to be ascertained whether there has been a deficiency of service with regard to the regulated entity, the bank, or not. Now, and there is a first resort mechanism prescribed under the banking ombudsman scheme, where the complainant has to approach the regulated entity, the bank, with his complaint. In this case, which was not done, and therefore the complaint was closed. So that's following the due process of law only. The complaint was closed. Now, under such circumstances, whether at all today a writ is maintainable, especially when my learned friend is aggrieved by the finding of the police authority, whether there has been a proper investigation or not. As I have pointed out from paragraph 5, and Your Lordship will find that respondent number 3 is the Commissioner of Police. It's basically on police in action. It's not on the summary action of the ombudsman, which the ombudsman can give any kind of conclusion to the, or can provide any logical conclusion to the investigation which has already commenced. So it is beyond the purview of banking ombudsman. That's my respectful submission before Your Lordship. Because Your Lordship will also see, just for the sake of completeness, page 9, prayer A. Prayer A. That's the prayer which has been sought by my learned friend so far as banking ombudsman is concerned, to set aside the telephonic message against the complaint vide 16 January and immediately do some needful steps about the prayer of recovery. Now, recovery can only take place after the investigation reaches its logical conclusion. Prior to that, banking ombudsman summarily cannot decide. Those are my respectful submissions.
Yes, sir.
Your Lordship. My learned friend elaborately stated now that what is the system of complaint closed by their authority. They said that they forwarded the telephonic message. I agreed in the telephonic message. And they stated in the bottom that based on your response, the complaint is closed. Has RBI CMS as first resource complaint. So I don't know what is RBI resource complaint, entire procedure, because I am a
No, but this order you must have got
Yes, yes.
subsequently.
This
One-
was
one
written
minute.
Subsequently, you must have received this.
I have received this and thereafter I
Why
came
did
here.
you bring this then to the on record.
And-
This has
and for-
explained everything.
Your Lordship kindly pay annexure P5, and they forwarded the matter regulated entity. So they did not ask any relevant papers before me.
No, you still not have understood.
Yes.
The submission which is made on behalf of ombudsman is this,
Hmm.
that according to the regulations, if you have any complaint against the bank, then first of all you have to make a representation to the bank itself saying that, look here, you are deficient here. You address the deficiency that I am alleging against you.
Yes.
If the bank still remains inactive or acts arbitrarily or does not take into account your complaint, then in that case, the second step will be to approach the ombudsman saying that I had complained to the bank, brought it to the notice of the bank that there is an illegality or irregularity committed by you, yet the bank has not taken action. So you kindly step in and direct the bank to take action. This is the submission
Yes,
that has
and
been
30
made.
days
Now,
is given
your-
to the regulated entity
Yes,
to
yes, it
resolve.
takes some time. Now, that is what is meant by saying first resort complaint. The first resort should be to the bank itself, that is the regulated entity which is regulated by the ombudsman, and then you approach the regulator that, see, despite my resort, nothing has happened. This is it.
I informed to the bank authority at the time of when the matter was debited. Immediately, I informed to the bank authority over telephone.
No,
Ah.
telephone
will
will
not
not
And
do.
no, Your Lordship,
There
it's
should
true.
be some evidence
And-
of that.
And
before you
thereafter I
and
filed.
when already a criminal complaint is has been lodged and that is being pursued by the police authorities, that will be taken to the logical conclusion.
And
I mean, it will be preempting that proceeding also if in between the ombudsman, because according to them, prima facie, though they don't find any deficiency of service because you have shared the password.
Yes, I have shared the password
Then-
due to that is my fault because
Then in that case, you cannot allege illegality on the part of the bank. If you had shared the password, then you have agreed to the amount being transferred.
Your Lordship, that's when matter was
there
filed
is-
before the CGM co.
There is
Done at CGM court.
there is no arbitrariness on the part of the ombudsman. Then in that case, writ petition, what will I do? You have shared the password. Now, if you have wrongly shared it or somebody has taken undue advantage of your sharing the password, then in that case, that is a criminal action which will be addressed by the criminal court.
So give me the liberty to file to the bank authority.
Lodge a complaint. You've already lodged it. The authority has directed the police to take action.
But my third prayer is there, commanding the respondent number 3 to immediate take appropriate steps. No steps till today.
Respondent number 3 here is the commissioner of police. Then it becomes
Who is
police
the
in
police in
action.
state?
Nobody represented.
That I can't.
Last time you said only ombudsman was
Yes.
served. Now it becomes the police. Now police is not.
And my instruction to begin with is that it was not served also at the proper place. That is why we did not appear.
And a prayer for compensation also.
Compensation and all it cannot be decided here in writ court. Police should be here. Can you serve the police authorities?
Ah, so I've also served. Previous date I have already served. Commissioner of
Unfairly, it is at the
And
Already submitted.
as I have handed up to your lordship,
Likhen in
that
short.
my learned friend has not disclosed also because he had received it also within the time.
This writ petition
oppose that application at
Since
first
my
because
application has not yet been admitted, Lord, I have been prevented to make the submission. So, my Lord, some grievance is also.
First, let me see whether the writ petition fails. Then your question of hearing you will come. Yes. Unnecessarily expanding the scope of writ
because
petition will not do. His grievance is against the state.
Yes.
If your grievance is against the state for a different reason, you can come up in a writ petition, not in this petition. Let us see. Yes.
Writ petition also point as involved in some.
So you can take this matter in a writ petition because your grievance is also against the state. If it is only against the private respondent, this is not the right forum.
Then my writ application is pending.
So that can be taken up whenever it is taken up.
If passed an order.
I'll not pass an order to discard you or not to hear you. I'll pass an order in his writ petition.
Then, your losses.
Yes.
Yes, my lord. It's my learned friend to answer. Your lordship remembers, my lord. It's the rules, my lord.
My lord, kindly sees my instruction is this, my lord. The instruction is on record. Your lordship has been record that. The instruction is the 31st of January 2025. Now, my lord, based on that, my instruction from the concerned respondent is this, that whatever be the interpretation, my lord, regarding non-production of certificates relating to a qualification. Now, the state respondent stand by that. Logically sees the rule my learned friend has annexed, but it would have been beneficial for us had he annexed a copy of his application. What declaration he has made. I know on the basis of that has been considered rejected. But for beneficial of this honorable court, my lord,
you have it.
No, my lord, I don't have also.
You have a copy of the application.
We have only submitted it, my lord.
You haven't kept a copy of it.
Declaration that part.
I'll just check up,
my lord.
application
But what we have submitted on 10th of January 2020.
No, the only question, my lord, if I may.
My lord, kindly sees the instructions which is on record, Lord.
Yes.
Kindly peruse. My lord, 31st of January 2025.
Yes.
The explanation provided by the state authority, Lordship, kindly have a look at this. My lord, only few lines, page 1 and 2. That is the explanation from the concerned respondent that why his candidature has been rejected. And my lord, it is based on a government notification that is an annexure Art 7. My lord, Lordship, I am tendering apology, it has not been designated. It is based on Art 7, the conclusion drawn by the concerned respondent.
But what about the rules which are given? Rules to dilam tage
Incomplete at the rules. Key rule.
হ্যাঁ তো বলো এই যে এইটা এক্সিস্টেন্ট আছে কি না আছে সেটা তোমাদের বলতে হবে আমরা কি করে বলবো we have not framed it হ্যাঁ no not 4A not 4A not 4A kindly comes to 5 এসো 5A এসো 5 of the rules.
Yes. Tell me what will I read? I will read the entirety of this. Show me then.
Yes, my lord, kindly sees annexure Art 7. The qualification of the qualification of the candidates.
Yes.
Yes. Now, my lord, candidates selected for the post of Mohammedan register shall possess a sufficient acquaintance with the Arabic language and Mohammedan law of marriage and divorce and be of a good moral character. Now, Lordship kindly sees this qualification has been interpreted by the concerned authority that the candidate, the aspiring candidate for this Mohammedan register should submit a certificate that he knows Arabic from any recognized madrasa or from any appropriate authority. That is the interpretation from the concerned officer. My lord, my learned friend, what he has done admittedly,
But he has submitted certificates by work on supplementary affidavit. He has filed those certificates before your lordship. That he has submitted 2 certificates from a Muslim scholar, from a headmaster of a madrasa, and the concerned DL and DLR, District Land and Land Reforms Officer. They are certified that he is accustomed with Arabic language and the Mohammed. They have certified him, but the interpretation, according to the concerned officer, who has rejected the claim of the red petitioner, that he should submit certificate from a competent authority, that is from a madrasa or appropriate equivalent to that. That is the interpretation provided by the concerned respondent.
Your lordship.
So why does that not satisfy the standard of sufficient acquaintance?
Because
Sufficient acquaintance, how do you judge?
Somebody, some individual, subject to correction, whether he is competent to certify or qualify somebody other than an appropriate authority that he is acquaintance with this particular thing, whether it is within the domain of an individual. Only I am putting this question to myself. A district land and land reforms officer, yes, he may be a Muslim scholar, maybe, but how it is within his domain to justify certificate in respect of a person who is aspiring to be a Mohammedan registrar. This is the difficulty. The supplementary affidavit annexed by my learned friend, it discloses that the certificate issued by the DL and LR. The interpretation from the competent authority is this: you should enclose certificate from a recognized entity that you are accustomed with this. This is the crux of the dispute, as far as I have understood. And this is the interpretation the authorities are making.
My lord, may I answer?
And what is your answer to the second question? There are 2 reasons for which your application has been rejected.
No, that is absolutely vague, because my lord, they are nobody to, my lord, they are nobody to see, my lord, whether these documents are original or fraud, because they are not the authorities. But my Aadhaar,
you have not allowed the court to complete the
Oh,
question.
sorry, my lord, I'm
you
sorry.
have anticipated the answer. The question was that you are not a local resident.
Yes, but I have given all
yes.
documents. Now the question is, my lord, they are saying
What
that,
documents have you given?
my lord, PAN card, voter card, Aadhaar card,
PAN card.
voter card, Aadhaar card, my lord, all the documents which I have submitted for SIR. Nothing.
Where is that? Page.
Well, kindly just give me a moment, my lord. কোন পেজ এখানে কোথায়? কি নাম আমার? কপিগুলো সব আসছে। Sorry. Fantastic.
Yes, which page? Where? Which
And
page?
The tiny comes to page 27
Of?
well, the read petition.
Page
Documents
27.
which I have disclosed for the authority.
Page 27 is your biodata.
Well, kindly see the enclosure, my lord. These are the documents which were enclosed with the authorities, my lord. Everything was disclosed, my lord.
Disclosure of voter card doesn't mean that the voter card is of that area only. Of which area doesn't so, because after considering this only he has said that no, you are not a local resident. That is what his
But voter,
conclusion is.
Aadhaar, everything was
Ah,
given.
very well, but what address is the voter Aadhaar considering that we don't know.
Well, just give. It is Election Commission of India. হ্যাঁ। Yes, well, everything is there. Because the Aadhaar card is there, voter card is there, well, electoral roll is also there. The local resident definition take under the act. দেখুন।
This doesn't appear to be proper. If his voter card and Aadhaar card are there, how can he say that he is not local resident?
And my lord, may I only read one note?
Please wait. Both of you, please don't speak.
Yes, your lordship has a particular question. But in the first page of the report, it indicates that at the time of making application, that is on 10th of January 2022, he was a resident of Shuri, whereas he is applying for MR in Rampurhat. That is the specific report, madam. Lordship kindly takes up the report, which is on record. 31st January 2025, madam, the second paragraph. It has been indicated that why such observation is being made by the concerned respondent. At the time of making application, if he has subsequently changed his residence, that is a different
It's
case.
not subsequent change.
Mine.
See the Aadhaar card and see the date of issuance thereof.
May I submit your one?
Sir, you have no audience now. You have not been added. Let them first fight and then.
Only document matter during pending of the deed application, one hearing was held by the collector, and the collector has observed that he is not the resident of the Rampurhat.
Where?
The certified copy, I collected certified copy. During pending of the deed application, the matter was already adjudicated. The certified copy of the here now.
এটা কোন লাস্ট সেটা কোথায় না আইনে কোথায় বলছে স্পেসিফিক ওখানে তো হি হ্যাজ টু বি ইন্ডিয়ান সিটিজেন আর বীরভূম ডিস্ট্রিক্ট হতে হবে কোথায় বলছে আইনে যে হি হ্যাজ টু বি ফ্রম রামপুরহাট বীরভূম ডিস্ট্রিক্ট হলেই তো হবে সেটা তো অন্য প্রশ্ন আগে তো
This is only a report.
This has never been served. Compassionate appointment.
So, my lord, I have no comments. So, yes, my lord, it appears from the document handed over to the lordship that
No, there has been a constant, my lord, endeavor to throw me out. Different peoples are lodged up, my lord, to initiate complaints against me so that, my lord, I do not get this compassionate appointment. Lord, this is a compassionate appointment. My father, my lord, was in service, my lord, for many years. I have been working as Nayab Kaji for 5 years. This is the real issue, my lord. দুজন মিলে একসাথে বলবেন না পেছনে যান পরে কোথায় বলছো বলো? হ্যাঁ, এই উপরে কত দেয়? এটা কোথায় পেয়েছে? প্রেফার্ড বলেছে, ম্যান্ডেটরি তো বলেনি।
No, he is right. You don't, your certificates also show that you don't have that qualification. Read the certificate.
Which one, Lord?
You have acquaintance with Arabic language. Requirement is sufficient acquaintance.
No, that is why I showed the rules. There is no answer to the rules.
The rules say,
Lord,
page 35.
Lord, this not the rules, Lord, which I have handed over to
Page
you.
35. See this. This notification is the rule. This has been substituted. Don't show me something which is not on record. Let us go by something which is there on record. Page 35 of a writ petition.
Yes, my lord. Look, this, my lord, we had, my lord, the discussion. Thereafter, my lord, I have come up with the.
Not a question. This is sufficient acquaintance. This is only acquaintance. Where is the mistake committed by the officer?
My lord, the question is.
Your own certificate doesn't show you are sufficiently acquainted.
Lord, my certificates are given by two persons.
Whoever has given it has not given it in the manner the rules say.
The rules are silent, my lord.
Rules are absolutely not silent. Rules say sufficient acquaintance.
Now, my lord, how the word
Exactly.
sufficient is to be interpreted?
The sufficient is missing. No interpretation is required. You don't have sufficient acquaintance. That is the certificate. Why should I unnecessarily import something which the certifier has not given? Why should I
The
unnecessarily?
certifier says, my lord, I have.
You have acquaintance. That is not going to do.
Maybe the word sufficient has not been used.
That's it. Both the certifiers have missed it. I am not satisfied.
My lord, then may I come back, my lord, with this, my lord?
Oh, what will you come back with? The certificate is there.
Lord,
What will you come back with?
my counter argument today is, my lord.
What counter argument, sir?
আরে দাঁড়ান, মামলা করতে পারছি না।
What
counter argument today, my lord, kindly appreciates one thing. My lord, this is my lord, in deviation of the normal notification or the normal public employment.
It is not in deviation at all. You have annexed the notification. This is Government of West Bengal's notification.
No, my lord,
earlier rules were
state substitute.
There is an amendment. You are placing something which is not there or on the rule book anymore. It says in the said rules, rule 4, substitute the following. So this has been substituted. This is what is in force. What you are showing is out of picture now. That is not to be considered.
Then the issue, today kindly
What
appreciate.
issue?
This is on ground of compassionate appointment.
Whatever, compassionate appointment is not
compassionate appointment.
Is more strict. It is more strict because it is creating an exception to the general general stream of appointments. So therefore, it is not by way of a right. It is stricter. So if your certificates also don't satisfy the standard, why should the court intervene? This is a certificate which has been given by two persons.
Kindly appreciate one thing. The person who is certifying, the person who is certifying would not write the word sufficient, adequate. But he could have written adequate also. He could have written anything else in English.
He has not written anything.
But he has written, my lord, I have acquaintance.
So that does not satisfy, sir.
Acquaintance and sufficient acquaintance not written by a certifier, my lord, are two different things, my lord.
Very well. That is why he said you should have brought then school certificates, Abul Fazil or something.
No, that is also not there in the act, neither in this notification.
What is there in the act is also not there with you.
Well, then the interpretation.
What is there, sir? You can go on arguing with me. It is not going to fructify. What is there in the act, you have not been able to satisfy on your own documents. That satisfaction is not there.
How tomorrow, if I bring a document, similar document, just adding the word sufficient, will the thing change?
I don't know. Today it is not there. Why should I speak about what is not there?
Age limit is 40.
The petitioner, I don't find anything unreasonable in this. I will interfere only if it is unreasonable wholly. It's a writ court.
Well, I can understand, but this is under compassionate appointment, my lord. Kindly appreciate, my lord.
Will give you a right.
A person, my lord, who
will give you a right to trump the rules.
No, I'm not saying to jump the
Then why are
rules.
you unnecessarily saying compassionate appointment? If you say 5 times, that is not going to bring down the level of the rules. The rules say
No, this
sufficient.
is not under a
I am
general
not-
notification, my lord.
It is there. This is a
But this is
government
not a
notification.
notification seeking appointment
Come
of
on.
marriage registers, my lord.
Indicate-
This is
indicate.
only on an issue when the person's father,
Sir,
my
I'm
lord,
not
is physically
satisfied.
incapacitated.
I'm not satisfied. I'm not interfering. This writ petition, please Yes, sir.
This matter is against WBSRDA regarding the non-payment of the dues during the non-payment of the dues relating to GST after the conversion of the GST from VAT during the financial. Kindly come to page 25, my representation dated 3rd October 2023. Wherein I have made one representative before the WBSRDA chief engineer. Till date, this representation has not been considered yet.
I am representing the state respondent number 1 and 3. That as it means that his grievance is against WBSRDA. Now, when the last occasion, whether if I can recollect, whether on by an order dated 7th of November, your lordship has direct to produce the contract unless subject to your lordship's approval, there is a specific clause in the contract under which matter he has undertaken work. But there is no scope of refund of anything as he has agreed in the respect.
Dispose of the representation, looking into it, whatever it is. Dispose of. I will clarify that this is not to be treated as a mandate to pay him anything. You have to dispose it of. He'll have to carry it. If there is dispute, who is the authority who will consider?
WBSRDA.
Who is appearing for SRDA? Then they have to be served again.
Tells them matter, what similar matter before the different
The authorities have to be there. Even
the state only represented WBSRDA on similar matter only.
Here he is not representing.
I'm only, as far as my knowledge, I'm only representing the part number 1, that is the department 1 and 3. So lordship may kindly direct the WBSRDA appropriate document to consider.
Where is WBSRDA? Only executive engineer has been made a party.
Executive engineer 4 matter.
Nobody is appearing for executive engineer. You can't appear for him.
Agency.
It's an agency. I feel
Then you serve again. Serve again. Without service, shouldn't pass.
Let them serve this SRD.
I had directed appear in service of notice on non-appearing respondents on 14th of November. Where is the affidavit of service? Not served.
Give me 1 week.
There is an order you should have served.
I'm praying for 1 week.
Despite an order dated November 14, 2025, service upon the
I'm for the petition.
For the Czech Union of India, led by Mr. Gautam Shah, Your Lordship.
I have, as per your lordship's order, I have served the SEBI and everyone, but the official service is being affirmed right now. I will file in the due course of the day.
serve it, serve and come.
I've already served my lord.
With your lordship's leave, if I may appear virtually.
You are appearing for?
I'm appearing on behalf of SEBI, your lordship. We have not received
Very
any document The order was passed on 7th.
You have not yet received the documents?
No, Your Lordship, we have yet not received the
Next week, if I keep, will you be able to get them?
Yes, Your Lordship. Next week will work. Your Lordship, I would request Your Lordship a week's
I am
notice,
appearing,
Your
my
Lordship.
lord, I am appearing for respondent number 4, my lord, BSc Limited, my lord, in this matter.
Very well. I am keeping it on 5th. Then will it be possible for all of you to be ready by that time?
Yes, my lord. We will
Yes,
be ready,
Your
my lord. by 5th.
Yes, Your Lordship. 5th December is all right, Your Lordship.
5th. Since it is submitted that you are appearing, madam, for SEBI.
Yes, Your Lordship. Respondent number 1.
Respond to.
Respondent number 1.
No, two. One is union.
It is submitted on behalf of the respondent number 1 that all the documents have not yet reached the learned council appearing for the said respondent, and as such time is prayed for. Full stop. List this matter once again on December 5, 2025. 5th December.
Oblige,
Yes,
Your
my
Lordship.
lord. My lord, I am appearing for BSc Limited, my lord, respondent number 4. My lord,
Please
kindly
give your
my-
names. Give your names. Give your names.
Yes, my lord, I have.
Unit 21. Well, I'm appearing for the petitioner. I'm being led by Mr. Aniruddha Chatterjee. This is the affidavit of service on the last official by the director to serve. Well, this matter is related to RTI. School has purchased some plot of land. If your lordship kindly take up past annexure as page number 23. The school is registered under Society Registration Act. Thereafter, my lord, the record of right.
Yes.
From page number 24, my lord. Now, my lord, if your lordship kindly take up at page number 30. After purchasing of the land, my lord, I have mutated my name, and as well as land has been converted into school. If your lordship kindly take up page number 30.
Yes, I've seen.
Yes, my lord. Subsequently, I have paid all the khajnas and everything. So what happened, my lord? Thereafter, I have received a notice from the estate officer, railway authority, stating that, my lord, the land has been acquired by the railway authorities. My lord, being aggrieved by the situation, where I have appeared before the estate officer, thus matter is pending. And during pendency of this matter, but I have made an RTI. If your lordship kindly take up my RTI application, page number 45.
45.
I will see 3 questions I have made. In whose name in the land under such and such dag number recorded, whether any public authority have acquired any land under the above mentioned dag number. If any land under the above mentioned dag number was acquired at any point of time, then by whom or which government authority was the land acquired, and in which year it was acquired. This is the simple question, but no reply was given. But I have filed an appeal. But in the appeal, my lord, a reply has been given. If your lordship kindly take up page number 49. They have transferred this matter to the, because it's related to acquisition or requisition, it has been transferred to the additional district magistrate, Howrah, land acquisition. Now, my lord, I have made an application before him on 21st March 2023. Now, my lord, one reply I have received, that is on page number 55. I will kindly see page number 55. The desired information is not available with the office. Thereafter, my lord, page number 57. They have given a reply in response to the application by the RTI being bearing this office docket number such and such. He is required to supply the LA case number, project number for recovering the receipt information easily and immediately. My point is that, my lord, if the property has been acquired by the authority, they must have the record with them. I'm seeking nothing. Just if the property is acquired, but as such, I have received a notice from the railway authority. The proceedings pending before the estate officer. So it will be easier for me to, my lord, proceed with the matter before the estate officer. A simple question I have given. From 2022
and it is 2025.
Give them the information.
Issue is very short and simple. Upon getting page 23, my learned friend swung into action. Page 23.
Very well. Now they want
Lordship,
some
I have
information,
already,
give them
I'm answering it. I'm answering it. Here and now I'll be answering it. So, my lord, what is the prayer? May I respectfully invite your lordship to page 20. Furnish information.
Yes.
22nd December 2022. That is page 45. Kindly, my lord, if your lordship kindly comes to page 45, what information does he want? In whose name the land, tag number 3, there are 6, 3, 4, 5. 5 LR plots. He asks for information. Not given. So he approaches under section 19, page 46.
Yes.
This is page 46, section 19 RTI.
Hmm.
Now, what this authority does, they give a reply that is at page 57.
Hmm.
So now, after getting the brief, I got the information. His query has been answered. From this, it will appear. These plots are subject matter of 2 land acquisition cases. May I respectfully hand over a copy? It has been answered.
Matter over.
And requiring body was Railway Authority. After that, copy. Problem. You take my copy, please. Xerox corner. It is marked. All these 5 ducts, the subject matter 2 land acquisition cases. One is LA 1960, LA 14 of 1962.
Very well.
And second one is LA case.
So you have written them about this. Written to them about
No, I
this.
have not
For
received.
the first time, upon getting the brief, I contacted. And this is the answer he is getting now.
Yes,
So, Lordship, kindly compare. Lordship, we can dispose this.
No, no.
Kindly compare page 45. Kindly comes page 45. Let us shorten the issue. Kindly comes to page 40. That was the information which he wanted. Kindly comes to page 45.
Page 45.
Lordship, in whose name the land, tag number 3163, 3164, 3165, 3166, 3181, in whose name? Whether in public authority have acquired. If any land under the above are acquired at any point in time, by whom and which government? Now, kindly may I respectfully invite your lordship to our instruction. Kindly comes, this is the first paragraph. LR plot 3163, tallied 3164, tallied 3165, tallied 3166, tallied 3181, tallied. Corresponding RSCs, they have given corresponding RS. So acquisition was done on the basis of RS DAG. Now kindly see, so far as 3163, 3164, so far this corresponding DAGs are these 4 DAGs. So kindly comes to para 2.
Yes.
These 2740 corresponding DAG of RS and 2741 and 2756 are subject matter of land acquisition case number 14 of 1961-62. Roshi got it?
Yes.
And so far as 2739 RS DAG is concerned, it is subject matter of acquisition. Roshi will get in para 3. LA case 8 of 1963-64. So all these DAGs, LR plots corresponding to RS are subject matter of 2 land acquisition cases. One is LA 14 of 1961-62, another is LA 8 of
Yes, sir.
1964.
Yes, I have perused the report, my lord. If your lordship kindly give me a
And
deadline, then it will be disposed of accordingly.
It was an acquisition under Act 1. Act is Act 1 of 1894. Possession given to the Calcutta. So everything finished. Award also done.
Got the information.
What more?
No, I have got the information, my lord.
Then
it's enough for me now. For the at this stage, I think it will serve.
Next you defend your case, that is. And they are saying that they are post-vesting purchases. They are telling in the last paragraph.
Before the estate officer, my lord. Suddenly I have received after purchasing a lot of land. It's a school authority, my lord.
Now you have got the information.
Redress.
Yes, I have got the information.
I mean, meticulously I have seen it. That's why I wanted this. That's why they have given this. Redress. Redress.
The petition. কি রে নামটা? 28 না? None appears for the petitioner. No accommodation is prayed for. List this matter under the
Next matter. Well, this is my application.
That's right.
On the last occasion, your lordship directed to the state.
My lord, I served the state, my lord, your lordship's direction, the affidavit which was filed by the respondent bank.
The report be submitted.
Bank already served. What has happened? I talked to district magistrate matter. What has happened? 2018, order was passed, section 40. After that, possession handover to the borrower with presence of the magistrate.
borrower.
Not to the borrower,
Bank.
to the bank.
Bank. Sorry, bank. With presence of this executive magistrate, police, so and so. After 5 years,
Yes, that is our case.
Where is the provision, 5 years, back, we have our part. What is the our part?
You have brought the judgment of State Bank of India versus State of West Bengal. Similar thing had happened there.
Yes, my lord, I have not brought
The
that.
borrower had barged in.
Yes.
The bank had gone to the magistrate. Magistrate had been directed to reopen the padlocks and let the borrower enter, the bank enter. I said that on the last occasion. You bring that. Then why are you making this submission?
My lord, all that we are praying for
Why
is
are
the
you making this
restitution of the possession which the lord, which your lordship.
In any
had
case,
executed
suppose today and
magistrate.
again an application under section 17 can be filed or not. It can again be filed. Then what is the use of coming up with this kind of an excuse? Sir, I have understood your problem. The borrower has broken into the premises once again. Now, suppose they file a second application under section 14 and not an application seeking implementation of the earlier order. What will you say? You will not act on that? Then this excuse is a lame excuse. It's no excuse at all. Very well. After 5 years, they have done that again. The property is not yet sold. It's still under surfacey. Proceedings are continuing. Section 44 obliges you to do that. Again, if they come for your assistance, will you not grant them assistance? Then why are you making this submission?
Page number 33. They made an application proper way.
Sir, I have understood that. They have made an application. On their application, you have allowed section 14. You have granted them police protection. And you have given the property to the bank. From the bank, if the borrower takes over again, will they or will they not be entitled to file a second section 14? Is there any bar that second time section 14 cannot be filed? Then there is no bar in implementation also.
My humble submission before your lordship, bank made an application proper way, we will consider.
That is the proper application. Seeking implementation of the order. You have decided on section 14. You please give them possession once again. Where is the bar in law? Show me the bar in law that you are barred. No, then your district magistrate has instructed you. Ask your district magistrate to show the bar in law. Where is the provision where there is a prohibition on you to implement your own order? Your own order is being violated. You will not implement it and you will show the law to court that no, it has been done, therefore I cannot do it again. Where is the law? So section 14. Please read section 14. Please read section 14, sir. Then this thing was already argued on the last occasion. There was no occasion for you to come and say this again. No, first day I said that there is a judgment of this court where it has been said that it can be re-implemented. I said this or not? You are making a submission again on the same lines.
I will not appear because we are not party in this proceedings.
Sir, on the last occasion you had appeared. I had indicated this. You had taken it smilingly. Now you are coming up with another instruction which is contrary to what you said on the last occasion.
What's the status after service?
No question of status. If they have filed an application before you, it is not required to be under section 14 again. It is a request for implementation. Why will you not grant police assistance?
Second time on 24th September, within 2 weeks, we will dispose of this application.
Well, the application is not needed to be disposed of. The only thing is that.
Have you brought the judgment or not? Nobody has that judgment. State Bank of India versus State of West Bengal. That is a judgment of this court, of our court, maybe in 2024.
Lordship keeps the matter on Monday, Malad, I'll pray.
You please instruct your officer saying that that is not the law. He has to go by the rules of, those are very strict for the purpose of ensuring credit. Then why are you making this kind of submission that no, if he has barged on, then I will not, I have granted once. You are only to assist the bank. That's the duty, because it is going to ensure recovery. Somebody has purchased the property in auction. He is holding outside. You will not help them. This is unfair, absolutely unfair. The borrower is taking advantage of the machinery. The borrower is taking advantage of the bank's money. You are helping the borrower. You are working against the cause of the nation. That should not be done, sir. That should not be done. I had made it clear on the last occasion. You are not going through the judgment. Bank also, you have not carried that inquiry.
I was not keeping.
Be abreast. There are several other judgments. There is judgment on other division bench of Madhya Pradesh High Court. You should be abreast of this. These judgments are quite often passed by courts. Implementation of the order passed by the magistrate has to be done. Yes. It would be another thing if the property was not of the secured creditor anymore. It was handed up to the auction purchaser. From the auction purchaser's hand, if the borrower has taken, then the DM can wash off its hands, say it is not my role. But Hinden Forge is there. Then this Blue Coast Hotels is there. Two Supreme Court judgments where it was earlier the position of law was that one section 714 application has been filed, possession has been given, DM becomes functus officio. This was overturned by the Honorable Supreme Court in either of the two, either Hinden Forge or Blue Coast, or maybe both, where the Honorable Supreme Court said that no, till such time that you give possession to the bank, your duty remains. Now the law has furthered. I mean, the object of the law has again been furthered by another judgment of this court as well as Madhya Pradesh High Court, recent most, I think, where it has been said that even if the law is broken by the borrower, he re-enters into possession. Then also it is still at the stage of surfacey. Surfacey action will be closed upon the bank list this matter once again on please implement your own orders. Your own order you will not implement.
My lord, and in the second order, my lord, DM order has been passed, but no police protection given.
Then there is a section 14 also pending.
Yes, ma'am.
See, what about that? On the first, you are vociferous. What is your submission on the second? That is the first section 14 application. That also you have not disclosed.
Yes.
What is the instruction of your DM on that? It is your matter only. Then he has no law to show there. Here he was showing law to me. In the next matter, there is no law to be shown because that first section 14 is also there. Ask him to be active, sir. Ask him to be active. This is not the way. That is the first section 14 application. You just now heard. No, not just receive. Last week you were there. I indicated it to you. Please help the cause of the nation.
I'll be carrying the charges.
Next one. Get pulled, Your Lordship. Both the matter 12.
Yes.
Great.
Oh, same order. 12th. I had asked you to file a report, isn't it? Where is that report? What does the report say?
Also, my lord, we have lodged a FIR, my lord, against this.
My FIR is lodged by the
FIR,
bank.
FIR will be lodged by bank. Why will the DM lodge an FIR? Where is the report of the DM? There was a report detection. देखिए फाइल का दुटो ही दी.
That the problem is, my lord.
The problem, whatever problem it is, it should be there in the report. Then why has the report not come? Shall file a report as regards action taken.
One is more time, my lord, because my lord, this last.
Record করে নিন. Learned advocate appearing. রিপোর্টটা ফেরত দিয়ে দিন. Mr. Banerjee, state respondents are the main respondents.
Yes, Lord, I have got the copy. This is the notice we have state respondent.
I'm waiting for this thing.
Lord, short point, Lord. Large case was given in favor of the writ petition. Lord, that the for the purpose of Lord, that tender was for land survey using different global position system. Now, Lord, that has been, according to us, Lord, 75% work has been completed. Now, Lord, according to them, Lord, a so-called notice was issued and it has been cancelled. Now, Lord, I cannot argue on that because, Lord, in the meantime, the work order was given to third party and third party completed the work. Therefore, my Lord, my case would be for damages for which I shall go to civil court for the purpose of the first prayer. Lord, I cannot argue before your Lordship because I cannot get the relief even if I succeed on the first point. Now, Lord, the second point which we place before your Lordship, the so-called notice, blacklisting. Lord, blacklisting order was given. Lord, in the so-called notice also it has not been mentioned that why you are not be blacklisted. Lord, Supreme Court said that in the
page.
Lord, page, my Lord, so-called notice is that page. Lord, so-called is that page. Lord, page 57.
Page 57. Yes.
No, not 57, my Lord. This is
page 57 is agreement.
Yes, my Lord. Lord, page 75.
Page 75.
75.
Page 75.
Lord, this is so-called with regard to the written explanation. We are not concerned with regard to that. This is the page 76A, my lord. Page 76A. Kindly look to this so-called notice. The reply for Karuna, so-called service. So-called.
81 is a super notice.
No, that is explanation, 81 explanation. Now, Lord, it has been cancelled.
What does a 101? Order, order.
Yes, sir.
Your lordship, what is Lord, that the blacklisting has been passed.
Where? Which page?
That is
101.
101.
101.
Page 101.
Yes, 101. Lord, towards the bottom, 102 Lord, towards the bottom.
Yes, I have got it.
Now, Lord, in the so-called Lord, there was no such. No such incident was.
No cause is at page 76.
Yes. Now, Lord, we have this.
No cause is about 4.1.5
yes.
of NIT. What is?
That's it.
Where is 4.1.5?
Lord, that is default 1.4.5. Lord, you kindly come to that. Okay.
Where is the NIT?
Lord,
NIT is page 15. Loss 4.1.5. Where is the NIT?
Lord, NIT, we have annexed, my Lord. Practically, there was no, Lord, in the so-called notice, there was no whisper why I shall not be blacklisted. Lord, we have said that in the
No, but
NIC,
they have referred to a clause in the show cause
they refer
4.1.
to a clause for the purpose of default termination
Where
calculation.
is that clause? That is why I want to see whether that clause contains any blacklisting tool.
Lord, page 20.
Page 22.
Page 22.
Yes, page 22.
2.1.5.
Yes.
Compensation and penalty.
Very well. So this clause does not contain anything about blacklisting.
Your Lordship.
Yes.
Therefore, my Lord, I have taken in this point, my Lord, your Lordship kindly look to the Lord supplementary affidavit. Specifically, I have taken this.
Supplementary affidavit. Yes.
Supplementary affidavit, I have taken this. That as per tender condition, paragraph 3, my Lord. As per tender condition number 4.4 and 5, it appears that the authority can terminate the contract by giving 15 days notice in the event of breach of clause 4.5 BII of the tender
Yes,
condition.
yes, got it.
But there is no clause in tender condition for blacklisting the contractor. Normally, your Lordship then kindly skip over. No notice was that paragraph 4, respondent issued notice to so-called 7 days about written explanation for such undesirable delay, and no so-called or prior notice was given as to why the petitioner will not be blacklisted. That the petitioner gave reply to the notice explaining the reasons for the delay by containing almost 75% of the assignment has been completed in page 79 of the petition. So far as so and so Moja 100% ground survey was completed. The purported termination of contract issue speaks inter alia. Additional district magistrate and district land and uniforms officer Purulia and Purbo Medinipur did not accept the reply which was not supplied to the petitioner, and hence the director of land records and survey and joint land reforms commissioner terminated the contract. Just as far as this part is concerned, my Lord, I will I'll take this point in civil court, my Lord, for damages. Now,
Paragraph 6.
Paragraph 6.
Yes, I've read it. I've read it.
Prior notice was not
I've read it.
covered by the judgment of the Supreme Court. My Lord, your Lordship kindly look to the Dana. Lord, Supreme Court said this, my Lord, your Lordship.
Kulthia.
Lord, 2014. Yes, Lordship kindly look to this. Lord, paragraph 33 and 34. 2014, volume 9, FCC, page 105. Paragraph 33. And 34.
33.
Lordship.
Yes.
And a specific paragraph we have given. Lord, latest judgment is 2020 Supreme Court 5753. Lord, here also, Lord, same judge, another judgment was, few judgments are relied on, and Supreme Court said that at least in the so-called notice it must be given. Natural justice principles must be followed, and there must be a, in that so-called notice at least, why you will not be blacklisted also. Although there is no, Lord, in the NIT, Lord, there is no such condition mentioned.
Yes.
Lord, these are my submissions.
Yes. Yes, sir.
For the purpose of
Lord, may I take your Lordship kindly?
Yes, yes, please. Thank you.
Survey and mapping tender was floated.
No, his specific ground is that you have blacklisted him,
yes,
but you have not given him an opportunity to represent against the blacklisting, because show cause did not contemplate blacklisting, so he could not answer to that.
Kindly comes to page 54.
Page 54.
Memorandum of agreement. Pursuant to that, the work order agreement was executed between the
additional district magistrate and the writ petition. All terms and condition is there. In the event of failure to complete the time within the stipulated period, what will be the effect? That is there. And arbitration clause is also there in that agreement. Now kindly comes to page 56.
Page 56.
Page 54, the memorandum of agreement. This is between the additional district magistrate and district land and land commission Purulia and the writ petition. The paragraph 3 of the said agreement says the survey to be completed by a second party within 8 months from the date of execution of that. Now, I am reading from paragraph 8. Time is the essence of this contract in case the second party fails to deliver the part or whole part of the survey work in terms of clause 3. Clause 3 that is the time mentioned of this agreement as per the terms and conditions, the tender papers and the annexure thereof agreement shall be deemed to have been terminated, whereupon first party shall be liberty to forfeit. So this gives us power to blacklist and terminate that agreement. And my learned senior friend submitted in the so cause notice. We have never said the reasons for. Page 81, another so cause notice was delivered to the writ petitioner. Our specific case are you are in the law in progress, and in reply they said they have no such manpower to expedite that. So we have to
but why did you blacklist? You will list so that he can respond to it.
No, we have after
terminate, yes, contract terminated. Very
now,
well.
Now page 81.
Page 81.
Page 81, we have said last paragraph, you are hereby submitted written explanation why any action should not be taken against him.
Yes, so you terminate. That is all right. But blacklisting, where that is, blacklisting is a stigma. He will not be able to participate with any with this he'll not be able to enter into a contract with this department for 3 years. That has an effect on that. He should be heard. He cannot be condemned unheard.
But my instruction is there, he was given opportunity and that
it has to be on paper. It is not in clause 8. It is not in 4.1.5. Clause 8 also it is not there. 4.1.5 also it is not there.
to that effect, I have to take my
No, I am disposing it off. I'll set aside the blacklisting. You have to
Or I have it for the petitioner.
What is the matter, sir?
The matter in the petitioner was the teacher in charge of our primary school, preschool. At that point of time, there is a scheme for giving the cooked midday meal, and the petitioner spent of rupees more than 3 lakh of his own pocket for the use of cooked midday meal, for running the cooked midday meal regularly. And there is a meeting also held in 2014, but thereafter the account should be changed to the different person, but the authority are not released is the amount which he spent of his own pocket, and he wrote a letter to the authority and submit a utilization certificate also. Also, kindly for a moment to the annex of page 26.
Page 23.
Page 26.
26.
Yes, this representation of the petitioner, and 25, 26. And at that point of time, in the year 2013, only a writ application. 2015, the petitioner filed a writ application, and the said writ application was dismissed for default. This is the second writ application. What is the
Yes, madam, what has happened?
Lordship, there is a misappropriation of font, Lordship. I am having the report, but this is only one copy. So, Lordship, allow me to put it on affidavit. Then, because there is a misappropriation of font, and there are statements of other teachers also there, that how the midday meal thing has been misappropriated by the petitioner. So, if your Lordship kindly look it just once. This is my copy. Put a distance na.
Just a minute, madam.
several meetings was held on?
Very well. Yes, madam. Yes, I have got it.
Yes. Lordship, there is a
My lord. So today, this has been fixed for maintainability.
Yes.
The last week, they raised this objection. They say, okay, they have no problem with Article 227, but they have problem with 226. I should refile it 227. Now, your lordship knows the case is filed as 226/227. I'm not the first one doing it, but I will take you through number of Supreme Court, 4 judgments now, including one very recent one. They're saying it has to be filed in 226, not 227. So the position is, what they're saying, it could be filed. I mean, the law settled by Supreme Court in Omaxe B, and then followed by that insurance case, which I have annexed. That's the law. Now, why this law came? So Consumer Protection Act 86, they had appeal against NCDRC only to the Supreme Court. But that was repealed in 2019. And the new law, Section 58, they have divided that. I will show you that, okay, it could be filed original writ petition under subsection 1 and 2, or when an appeal comes from a lower court, state commission, at section 3. So this case came in the Omaxe B first time in Supreme Court. A case from the state, it came to Supreme Court. Supreme Court laid down the law in that one first, that, okay, this law, the new law, makes it, if it is an original jurisdiction, NCDRC passed, then you come directly to Supreme Court. But if it is on the appellate jurisdiction from lower court, then you have to go to jurisdictional high court first under Article 226 or 227. I'll show you. This is the language.
Yes, yes.
Or
226 or 227.
Or 227.
If 227 is applicable, or if 226 is applicable, that is how it is to be read.
I will show you the exact wording.
Yes.
I mean,
because I have read it, it says as the case may be. As the case may be.
Yeah, the most important one, which every subsequent judgment cited, is that insurance. So on page number, universal, yeah. On page, I have annexed the whole judgment.
Yes, yes.
Page
144. Yes.
And I'll just take you through the relevant paragraphs only, which are very relevant for this case to decide, and the subsequent following this Sompo case. So if you can kindly come to paragraph 12 of this judgment. You got that? Paragraph 12. So it says, in the course of the hearing of this matter, manifold.
Sir, which page are you referring? Page?
Okay, page 151. 151 of my writ appeal. It is annexed.
Yes, 151.
In the course, paragraph 12. In the course of the hearing of this matter, manifold contentions were raised on either side. However, the moot question that falls for our consideration is whether we should entertain this petition seeking special leave to appeal under Article 136 of the Constitution directly against the order passed by NCDRC in exercise of its appellate jurisdiction, or relegate the petitioner to avail the remedy of filing a writ petition under Article 226 of the Constitution, or a petition invoking supervisory jurisdiction of the jurisdictional high court under Article 227. Right. And then paragraph 17, page 153.
153, yes.
Para 17. A plain reading of the aforesaid provisions, as I went over the provisions of the 1986 Act and the 2019 Act respectively, would indicate that the remedy of appeal to this court is available only when, with respect to the orders passed by NCDRC in exercise of its powers conferred under Section 21A1 of the 1986 Act and Section 58(1)(a)(1) or 58(1)(a)(2). These two are the original jurisdiction of that 2019 Act. In other words, both the acts provide for the remedy of appeal to this court only with respect to the orders which are passed by NCDRC in its original jurisdiction, or as the court of first instance original orders and no further appeal lies against the order which are passed by the NCDRC in exercise of its appellate or revisional jurisdiction.
Right.
Adverting to the case at hand, this is the case. The appeal before NCDRC was against the order passed by SCDRC under Section 17(1)(a)(1) of the 1986 Act. Such appeal to NCDRC was maintainable as provided under Section 21(a)(2) of the 1986 Act. As per Section 23 of the 86 Act, any person aggrieved by an order made by NCDRC in exercise of its powers conferred by Section 21(a)(1) may prefer an appeal against such order to this court. Therefore, an appeal against the order passed by NCDRC to this court would be maintainable only in case the order is passed by NCDRC in exercise of its power conferred under Section 21(a)(1) of the 1986 Act. No further appeal to this court is provided against the order passed by NCDRC in exercise of its power conferred under 21 so and so. Then the paragraph 39, which is page 162.
Yes.
In the aforesaid view of the matter, we have reached to the conclusion that we should not adjudicate this petition on merits. We must ask the petitioner herein to first go before the jurisdictional high court either by way of a writ application under 226 of the Constitution or by invoking the supervisory jurisdiction of the jurisdictional high court under 227 of the Constitution. Of course, after the high court adjudicates, they can come. So this is the settled law. Then following this, a whole bunch of cases have happened over high courts. And the latest one I will show you, Your Honor, Supreme Court, 2025.
May I get a copy?
So let me finish. So the first one, Your Honor, I have handed over. It's an High Court, Orissa.
It's Kalinga Eye Hospital and Research
Kalinga Eye
Center
Hospital versus Bhagavati Sahu, another. So, I have chosen only the medical negligence which came in this case.
No problem.
So all in the, I'm not going into merit of that case, whether negligence or not. No. But what happened, the fact is, it was filed as CDRC, which actually found them guilty, then went to NCDRC. Then NCDRC actually also upheld State Commission. Then the hospital came. That's this case. So, and here, very top, cause title. It's a matter of...
Dr. Saha, I'm just disturbing you for 1 minute.
Yes, yes.
Before we proceed, I'll just indicate to you about the functioning of this court so that it is easier for you to appreciate the problem.
Yes.
226/227 is something which is acceptable in some courts, not acceptable in some courts. Why? I'll give you the example. In every high court, the determination is allocated by the Honorable the Chief Justice to the different courts.
Yes, yes.
Now, 227 jurisdiction is with one Honorable Judge who may or may not have 226 jurisdiction. 226 jurisdiction is with one Honorable Judge who may or may not have 227 jurisdiction.
Yes.
Now, in some courts, 226 as well as 227 jurisdiction is there with the same court, same Honorable Judge. So, if a petition styled as 226/227 is filed before a judge who has determinations of 226 as well as 227, it will be open for him to adjudicate the matter because he has jurisdiction of both the matters.
Yes.
If you approach a judge in a court where he has jurisdiction only either 226 or 227, then you will have to choose your forum.
Yes.
Whether to go for 226 or to go for 227.
Yes.
Now, there is a judgment of the Honorable Supreme Court, I think 2010, Shalini Shyam Shetty.
I brought that.
Where the Honorable Supreme Court has said that if you have to go for 226, all the respondents cannot be private players. One of the respondents have to be government player or a state authority under Article 12, or you have to show that there is a collusion between the private player and the government entity. It is only then that 226 will be maintained, otherwise 227 jurisdiction.
My lord, then I will show you just the latest Supreme Court judgment. I have passed it over, 2025 judgment. This is a case PGI, there's a hospital versus Devendra Kumar.
Yes.
Now, very short, but it's very important in context of this. In view of this court, then the appropriate court for the petitioner is to invoke the writ jurisdiction of the High Court under Article 226 of the Constitution of India against the order. So here they are saying it's only 226, not 227. And then I passed a division bench, Rajasthan High Court. That is very
they may entertain.
They may, but the proposition
Separate rules.
Yes, what they said there, they have explained the SOMPO very well. And they have explained that, yes, you can go either or. So in that
Sir,
case...
have you seen Shalini Shyam Shetty? You have it?
Yes, I have it.
Can you hand up a copy to Dr. Shah?
Thank you.
If you see,
Paragraph
I was also
51.
doing some research, paragraph 51.
51.
Yes.
Paragraph 51.
Mm-hmm.
Please read paragraph
It
51.
is well settled that a writ petition is a remedy in public law which may be filed by any person, but the main respondent should be either the government, governmental agencies, or a state instrumentalities of a state within the meaning of Article 12. Private individuals cannot be equated with the state or instrumentalities of the state. All the respondents in a writ petition cannot be private parties.
Yes, this
but
is where
I get it. I get it.
So
My
this
lord,
is
but
a
you
judgment
appreciate
which binds. Now, this was upheld by the Supreme Court in a later 3-judge bench judgment.
Yes.
I think Radheshyam or something.
My lord, this is a unique situation.
Radheshyam versus Chabilnath.
But Your Honor, kindly consider this. When Supreme Court passed far later than this order I just passed it.
Sir, in Delhi, it may have been permissible.
No, Supreme Court. This Supreme Court.
I understand, because the order, you must see the order also.
It says...
order from where it has come, the order from which High Court was challenged there, it was not Calcutta High Court. This order which PGI...
the Delhi one.
PGI.
That one PGI, yes, that's PGI. That's Chandigarh, yes.
This was Chandigarh.
Yes.
So in Chandigarh, 226, 227 may be with the same court, which is why this kind of an order has been passed by the Honorable Supreme Court.
My lord,
in our High Court, rules are different. Here, if you have to challenge it, then in that case, either government agency or a state agency under article which answers the definition of Article 12 has to be a party, or 227. 227 you can of course approach even with private players. That is why Supreme Court has cautiously said 226/227, so that it is clear that in cases where 226 is not entertainable, 227 will be there. But otherwise it would have said only 226.
If I can, the division bench Rajasthan, I understand what your lordship says.
Rajasthan,
the Rajasthan may be different,
yes,
but they are explaining the proposition based on the
no doubt at all.
That they are saying
we cannot doubt, because we are
that is binding. That is binding. It is binding. Yes.
Only thing is how we will apply it.
Now
it says 226/227.
Right.
There, since it is using 226/227,
yes.
we have to give a meaning to it.
Yes.
So 226 in cases where 226 is applicable, 227 in cases where 227 is applicable.
No, but the latest one saying it is only 226.
No, this is
I just passed you.
Because the latest one has been passed in respect of a judgment passed by
from
Punjab.
Chandigarh.
Yes. So Punjab and Haryana High Court may
they are not saying that.
No, we are not.
This is a big. My lord, one humble submission.
Yes, sure.
You see, this writ petition, I agree. Principally, I agree. It is not really, should not be a writ petition. It's an appeal. It's actually an appeal against NCDFC.
Would be the best thing to say.
Right.
Appeal is not provided for statute.
Right.
Appeal is a creation of statute.
Yeah.
It is a revision.
So it is, true sense, it's not a writ.
But a revision,
explain the law.
Revision is 227. Revision is 227. 226 would have been open. For example, suppose you can also go to the consumer forum against a government body's deficiency.
Yes.
You can also go.
Yes.
Now, if you have gone before the Supreme Court against a government, before the consumer forum against a government body's deficiency, then that government body is also a party to the petition. For example, in this writ petition of yours, instead of the two or three private persons, one party had been, say, a government agency. Then in that case, RIT would also have lied, because of we cannot ignore Shalini Shyam Shetty also. It is a judgment prior in point of time, affirmed by a 3-judge bench. We cannot ignore that. Now it clearly says. So now, once we are reading the later judgments of the Supreme Court, we have to read in a manner that all of them are consistent.
But that Omaxi B, Sompo, and now this latest one, they are now most medical negligence cases is against doctors and hospitals.
Sir, 227 is there.
My lord, but 227 I can't. They are saying, I mean, how? Just read this. It is binding. It may be Chandigarh or whatever. That means each state I have to go and see that, okay. The Supreme Court didn't explain. I mean, that is, in my opinion, humble opinion, my lord,
Sir,
the appropriate course for the petitioner is to invoke writ of the High Court under Article 226 of the Constitution.
Sir, let us understand this. Does that mean that in universal Sompo,
yes,
whatever was said has been undone by this court, by this judgment? It can't mean so.
No, they are following that.
Therefore, 226/227 has to be given a meaning. We cannot even overlook Shalini Shyam Shetty, because this judgment is also Supreme Court judgment. This is also binding.
Yes.
So interpretation, when we are interpreting judgments, we have to interpret it in such a manner that all the judgments become consistent. What will be that interpretation? That is why when we say that when we are interpreting a judgment, we will not interpret it as if it is a Euclid's theorem. We will not interpret it as if it is a statute. The moment we say that Supreme Court has said that you can go in writ, then only writ will lie. We will be reading it as a Euclid's theorem, because we will be reading it by keeping our eyes close to Shalini Shyam Shetty. We will be reading it by keeping our eyes close to the oblique 227 part of universal Sompo. All of these have to be undone. This we should not.
So, your lordship, is it you are saying what you are saying? That means even if I withdraw this, refile as 226 only, then
226 will be a problem. 227.
227 will be a bigger problem. Why? You see that division bench, they said you cannot do 227.
No.
And now the Supreme
Court cannot do 227.
No, the division bench I just passed you on, I will read. They say, in fact, they are here, that one, the Rajasthan High Court.
66 of Shalini.
My lord, Rajasthan, I just read. I understand that. There's no point harping on that one.
Rajasthan.
But Rajasthan, I just hand you over that one.
Yes.
Here is the factual matrix of that case. There, same thing. It's a case building Consumer Court, State Commission, Rajasthan, went to NCDRC. Both of them allowed the complainant. Then that builder came to Rajasthan High Court, single bench under 227. And there, court saying, if your lordship just see paragraph 9, court said, paragraph 9, my lord, on that judgment, learned single judge has exercised his jurisdiction, treating the writ as having been filed under 226. However, from the bare perusal of the writ, it is evident that the writ was filed invoking 227. And that is why they overturned. So they're saying that's the mistake single judge did. It should have been 226, not 227. My lord, and towards the end, they have elaborately, and then Sombo is discussed, paragraph 12. That's where Sombo they have discussed. The Universal Sompo said, quoting, in the aforesaid view of the matter, we have reached the conclusion that we should not adjudicate this petition on merit. We must ask petitioners here to first go before the jurisdictional High Court, either by way of a writ application under 226 of the Constitution or by invoking the 227.
You have a copy of Rajiv Chaturvedi?
Rajiv Chaturvedi, I do.
Please hand up a copy to your learned friend so that he can have a look at it, because he will be required to answer.
You have, yeah.
Because this raises an interesting point. Rajiv Chaturvedi. Please see paragraph 13.
I will give you this. Sorry. Okay, you take this.
No,
sorry. No,
you can take this.
No, you want to keep it. So here, court said the mistake.
That is why I wanted you to read.
Kindly keep this. I am sorry.
Read paragraph 13.
More copies.
It raises an interesting point.
Yes. Yes, I was going to read that. You can read that. So, Your Honor, to me, it is clear, especially in view of the Supreme Court, that Chandigarh case, Your Honor is the right and the only place I can approach. If I
No,
file,
we are all learning, Dr. Sahab, we are all learning.
Your Lordship, you know far more. I'm not even a lawyer, my lord.
Not required to be. Law is, we say
Yes,
that
yes.
law is
No, no,
nothing but strong
absolutely.
common sense.
Yes. No, but I'm not a lawyer, but I must confess, last 27 years, I'm reading
This
more
is
law.
passed by the
than that.
Rajasthan High Court. If that
Very well,
is so.
but what about the logic? It may
Yeah,
not,
the
may not be
proposition.
binding on me. That I understand. It may not be binding on me. It has a persuasive value. I may or may not agree with this. But this logic appeals.
But this
That's
logic
it.
is directly in contravention to the law laid down by Shalini Shamshetty.
No, Shalini Shamshetty has not said that even if you don't have jurisdiction over the tribunal, you will entertain 227. It doesn't say that. You have to read it now. Now this has to be seen whether this interpretation is correct or not. This interpretation, whether this is correct or not, as to whether territorial jurisdiction would mean only that, or if there is only one national tribunal.
And my lord,
and
if
the
I
effect is caused, then
Yes.
whether that would give you jurisdiction. Territorial jurisdiction means how will you expand the definition or meaning of the expression territorial jurisdiction. This is an interesting point that has been raised.
The other point, my lord, I will be greatly prejudiced 227. I have to file in Delhi.
No.
That is clear from here.
That is
Calcutta
because of this.
cannot accept this.
That is because of Rajasthan's this judgment.
No, but they have cited, there is a case similar, not a consumer case, but similar thing, Calcutta High Court judgment, which was overturned. I think it's Alpana Bandopadhyay. Alapan Bandopadhyay.
Alapan Bandopadhyay was 226, not 227.
But if your lordship kindly sees paragraph 47 of Shalini Shamshetty once.
Yes.
But kindly comes to paragraph 47.
47.
It starts from paragraph 46 rather. I should start from paragraph 46. Article 226 and 227 stand on substantially different footings. As noted above, prior to constitution of the Chartered High Courts as also the Judicial Committee of the Privy Council could issue prerogative writs in exercise of their jurisdiction. However, after the constitution, every High Court has been conferred with the power to issue writs under Article 226. These are original proceedings.
You are reading paragraph 47?
46.
46, yes.
Now comes to paragraph 47. The jurisdiction under Article 227, on the other hand, is not the original, nor is it appellate. The jurisdiction of superintendents under Article 227 is both for administrative and judicial superintendents. Therefore, the powers conferred under Articles 226 and 227 are separate and distinct and operate in different fields. Another distinction between these two jurisdictions is that under Article 226, the High Court normally annuls or quashes an order or proceeding, but in exercise of its jurisdiction under Article 227, the High Court, apart from annulling the proceedings, can also substitute the impugned order by the order which the inferior tribunal should have made. The jurisdiction under Article 226 normally is exercised where a party is affected by power under Article 227 can be exercised by the High Court suo motu as a custodian of justice. In fact, the power under Article 226 is exercised in favor of persons or citizens for vindication of their fundamental rights or other statutory duties. The jurisdiction under Article 227 is exercised by the High Court for vindication of its position as the highest judicial authority in the state. In certain cases, when there is infringement of fundamental right, the relief under Article 226 of the Constitution can be claimed as ex debito justitiae or as a matter of right. But in cases where the High Court exercises its jurisdiction under Article 227, such exercise is entirely discretionary.
No,
and
please read Article 227, Constitution. You have it?
But today I am not armed with the Constitution book.
It is in Sompo. I think it is quoted in Sompo.
Read this. Didi, ektu din. Didi. The point is not without substance. The point raised by Rajasthan High Court is not without substance.
Power of superintendence over all courts by the High Court. Every High Court shall have superintendence over all courts and tribunals for the territories in relation to which it exercises jurisdiction.
Within the territories in relation to which it exercises jurisdiction. Now, if it is beyond the territory in relation to which it exercises jurisdiction, then whether 227 is available. If it is a tribunal, then that is another way of interpreting it. If it is a tribunal within the territory of the High Court and over which it has jurisdiction under Article 227, then in that case, yes, 227 will be the remedy. But the person cannot be remediless if 227 cannot be availed at all. Then what will happen?
Yes, yes. That's what I was saying. And also,
it is not that simple.
And this
because the
paragraph
point which had
47,
been considered by Rajasthan High Court, it appeals. It is
this
not an
Supreme Court.
unimpressive point.
My lord, one other point.
It's an interesting point.
My lord, one other point. By reading this, he was reading, my learned friend, it says 227 on the other hand is not original, nor it is appellate.
Correct.
My lord, this
Paragraph
situation in
66.
NCDRC, it is
Paragraph
appellate
66.
authorities.
No, that is why at the very threshold I said, Dr. Saha, it is not appellate, because appellate will be only when there is a provision for appeal. Appellate is a statutory provision. You cannot prefer appeal if there is no provision for appeal. Therefore, it is revision.
There is the 58 is appeal. That section 58,
Section 58, you are not
they have
coming to.
divided different
Yes,
ways.
so therefore, for not for High
But
Court.
it is appeal
Not for
against
High
the
Court.
judgment by NCDRC.
Yes, but not for High Court.
No, but Sompo and other judgment, they have said, yes, you go appeal, but in High Court.
No, they don't say appeal. They say challenge. Challenge.
Challenge.
Yes.
It's
Yes.
truly
Because appeal is a statutory word having very strong import. It can be taken into consideration, or you can say that I have a right to appeal only if that right is conferred on you by the statute.
Yeah.
Appellate right cannot, even right to revision. Right to file a suit, it inheres in everybody. I can file it.
So, my lord, if this goes for 227, there will be direct contradiction between
this point of yours.
But may I answer it? But I don't think it's not if I get a citation.
Kunta. Yeah, that one I gave you that copy. No, this is here. Give this. That's the one.
It is 2024.
That is SCC
online Rajasthan 365. 365.
Well, may I come back next week, my lord, with the copy?
You convince him, not me.
My lord,
I am ready.
My lord, your lordship knows I am here on the merit only. I want to show your lordship what has happened.
But I cannot shut him off.
No, I know. So your lordship has to pass an order on the maintainability.
Yeah.
And if your lordship said, no, you have to go to 27, then I don't know what I will do. I go to Delhi or challenge this in Supreme Court? Or?
Let us come to the maintainability. Let it be concluded. When do you want? Mr. Sahab, you can appear online also if you are not in Calcutta.
I know online. Also, from here, I will come. I'd rather do it like this because it's always.
Next Friday, we can do it next Friday.
Can we do it before that? Like
when?
Specially fixed. Any day. Any day. This is most important.
But he has to travel, my lord. Let him see.
I appreciate that. Monday, Tuesday, any day, my lord.
Keeps it on Wednesday.
Wednesday, I'll be having other matters.
No, then before that, I want it
Wednesday.
Maybe Tuesday? Yeah, they are okay with Tuesday. Is it possible, my lord?
Didi. Oh, Tuesday we have different bench. I'll be sitting.
Oh, Monday, not possible.
Monday fixed. Wednesday also fixed.
Then
Friday,
Thursday.
If we can have it as continuing matter.
Thursday.
Friday.
But
I will take it. Yes,
so if you have problem, then
no, I have problem. The problem is only I'm rushing for the reason because your lordship.
You are.
Your lordship, you know, honorable.
Okay with any day, my lord. He has to travel.
Yeah, you can keep it.
before the National Commission also.
That's can 2, my lord. That's can 2.
Kindly record our objection and then.
Of course. But you hardly have any scope to object. It's between the court and the litigation.
Only thing is that everybody says but that is allowed and becomes a regular practice, then everybody.
No.
I'm doing pro bono, isn't regular practice.
He was there representing this person before the National Commission, before the state.
All along from the state commission.
So it is not one-off. ঠিক আছে, বুধবার দেখি। বৃহস্পতিবার আমাদের কি আছে? তাহলে মঙ্গলবার দিন করতে পারি সেকেন্ড হওয়ার সুবিধা আছে? সেকেন্ডে ফার্স্ট হাফে যদি রাখি, ডিভিশন বেঞ্চ তো সেকেন্ড হাফে আছে না? Tuesday?
Yes,
Tuesday.
I'm grateful. Yes. Anytime. But I'm grateful.
Huh? Tuesday, no, please wait, don't go. I'll allow this can. Just a minute, let this be over. একটা লিখে দিন তো, can 2 is an application.
My lord, I am appearing for respondent number 1, my lord.
Very good. Can 2 is an application made by the petitioners seeking leave to allow Dr. Kunal Shaha to plead and argue in the writ petition, to plead and argue the present case on behalf of the petitioners. Full stop. It is noticed that Dr. Shaha had represented the petitioners. Please show me the orders where you have represented.
Yes. That NCDFC order? Yes. It is with the can 2. Can 2 I have in it.
Where is the order?
Yeah, the second page.
No, it must be annexed to the writ petition also.
Yes, it is. Not the can. With the can, it is.
Yes, with the can, with
Yes,
page.
can 2. Can 2.
Please take me to that page.
Yeah.
Page 70. 17. Yes, that Dr. Kunal Shaha had represented the petitioners before the National Consumer Disputes Redressal Commission. You had represented them before the State Commission also?
Yes, all along.
Where is that order?
Yeah, that order.
Page 43.
Page number 60. With my appeal. What is it? Yeah,
yes, Dr. Kunal Shaha is there. As well as before the State Consumer Disputes Redressal Commission, as well as the State Consumer Disputes Redressal Commission, and before this was the first complaint originally.
Kolkata.
Full stop. Comma, as the authorized agent of the petitioners. Full stop. It does not appear that the representation is malafide. Full stop. It is also noticed from the various orders annexed with can 2 of Now, from the order dated, it also appears from the order dated. Various now from the order dated February 21, February 25, February 25, 2022, that the petitioner has been passed by this court in WPO number 3 of 2019, that the petitioner has been rendering voluntary service to victims of medical negligence for a considerable time. Full stop. In such view of the matter, having regard to the peculiar facts and circumstances of the case, comma, notwithstanding the objection taken by the learned advocates appearing for the respondents, the Dr. Saha is allowed to present the case of the petitioners before this court. Can 2 of 2025 stands allowed accordingly. Full stop. Dr. Saha has now a point of maintainability of the petition has been raised on behalf of the respondents. Full stop. It has been submitted that the writ petition styled as an application under Article 226, 227 of the Constitution of India is not permitted by the rules of this court, and that while a writ petition under Article 226, can only be maintained against a person or an authority satisfying the definition of a state within the meaning of Article 12 of the Constitution of India, comma, only private persons have been arrayed as respondents in the present writ petition. Full stop. Dr. Saha has made his opening submissions and has relied on the judgments of the Honorable Supreme Court in the case of Universal Sompo, General Insurance, page 144. Page 144 of the writ petition. A Universal versus Suresh Chandjan, এটা copy করে নেবেন, and postgraduate এটা 2 লিখলাম এখানে, ঠিক আছে, ডেটটা দিয়ে দেবেন কারণ রিপোর্টেড নয় বলে। Full stop. He has also placed reliance on a judgment of the Honorable High Court of Rajasthan in the case of a Rajiv Chaturvedi, the 3 লিখলাম, ঠিক আছে, to submit that in the facts of the present case, a petition under Article 227 may not be maintainable, and as such, a petition under Article 227 may not be maintainable, and as such, the only avenue available to the petitioners to challenge the order passed by the National Commission, National Consumer Disputes Redressal Commission, NCDRC, is by way of a writ petition under Article 226 of the Constitution of India. Full stop. Mr. Das, learned advocate appearing for the respondents. Respondent number 2 has submitted that in the facts of the present case, the petitioner ought to have challenged the order passed by the National Consumer Disputes Redressal Commission only by way of a petition under Article 227 of the Constitution of India, 227 of the Constitution of India, in view of the law laid down by this court, by the Honorable Supreme Court, in the case of Shalini Shyam Shetty. R লিখে দিলাম, Shetty and another versus, এটা আমার কপি, এটা আমাকে ফেরত দিতে হবে, এটা ওদের নয়, ঠিক আছে 2010 volume 8 SCC 329 হলো full stop. Mr. Das seeks some time to answer the point raised by Dr. Saha while placing reliance on the judgment of the Honorable High Court of Rajasthan in the case of Rajiv Chaturvedi Supra. Full stop. List this matter for further consideration on December 2, 2025 at 2 p.m.
2 p.m.
2 p.m. so that we'll have some matters in the.
I will be in Delhi, but I will come in the morning. No, I have a case with the day before.
If you want some
but I
update-
will return. Then I will return. I will return. Two. December 2 is fine. I will come. I will.
If you don't come, we'll adjourn it to a next day, not a problem.
Yes. No, I will come.
At least one step we have
yes, yes.
gone ahead, we have understood.
No, no, I
because
asked for it.
this is an interesting.
But the only point is, my lord, the authority.
And one will dispose of
authority
after
which passes
maintenance
the
because
order.
maintainability is first. Not required. Not required. Not required because 200 days and odd doesn't mean. Writ petition is always within time. That will take care of. But the main point is the point which you raised, Shalini Sham Shetty. And Dr. Saha's salvo in Rajasthan. That is important.
And also the Supreme Court, 25.
Yes.
Item number 329, Lord, I have telephonic instances to appear on behalf of the private respondent. I am only seeking for a week's accommodation.
When the matter is called on, not now.
My lord.
They are suffering to use the bond fund. The bond has been given by the private sector illegally, my lord, and they made complaint before the DA. Now, if the land, DA has to take steps or show moto or I don't know.
If your lordship kindly see, the civil
Outsider, they are not related to the super.
civil court made an observation. Where I am the plaintiff. Plaintiff tells the defendants are holding the adjacent plot of land has already encroached some portion near about 500 and Doba property and are trying to encroach and fill up the rubbish on the said Doba and convert the nature of the land. The observation of the civil court, they are filling with the rubbish to the pot. Now they are coming before this honorable court. Lordship, kindly see. And injunction order is observation. Now they are claiming they want to withdraw.
Why? Why have you not brought this on record then?
And there is a direction.
So there is an order of injunction against you, isn't it? This suit has been filed by whom?
One injunction they filed.
This is an order of which where is the plaint? Where is the copy of the plaint? I don't find the cause title here.
Yes.
Sir, please wait, let him conclude. Both of you are speaking at the same time. It's becoming difficult.
This is the injunction, copy of the injunction.
Aziz Malik.
Malik is my client.
He is respondent in the writ petition.
I am, yes.
Which respondent? So he has filed a suit. What?
Expressing the material fact of
Please wait. What is the allegation here? Yes, sir. This Doba itself is a subject of the suit property. Suit filed by the respondent against you. No, not only that, filling up is also is there. That you are forcefully filling up. That is the allegation that you are forcefully filling up their Doba. And there you are approaching against the DM. No, sir. Whatever may be, it is there before the suit court. This read. No. After this point is taken of suppression, you want to withdraw and I will allow.
Authority in terms of the section 17A of the Clearing Act.
Yes.
Here about the signing of page 41. Second paragraph. Here the users. The user also some has co-owners of state corporate that we have been seriously prejudiced and has some prayer for restoration of form in its original position upon demolition made over there.
Yes, sir. If there is a prayer that the pond should not be illegally filled up, that is your prayer also. Why should the DM not restore the pond? The entire action is directed towards restoration of a water body. Why should that not be done?
Now, subject to the leave of the court. Lordship, kindly see. The civil court have taken all the points and have already.
Civil court will not be able to restore the pond. Civil court is not the authority for restoration.
Lordship, kindly
that is an administrative act. This will only decide title.
Now,
so far, whether you have illegally, if you are the owner of your own pond, and that also if you have illegally filled up, for that civil court is not going to
Now-
interfere.
Now, Lordship kindly see, status quo to be maintained by both the parties.
Very well, that is a different thing. That is
Sir,
it. Does that mean that that if you commit any illegality, that will not be inquired into by the district
they have
magistrate?
every right to file the contempt against me. Lordship,
That is different. Contempt action is different. If you there, one action may have different consequences in different law. Suppose an action is civil as well as criminal. Will he be prohibited from taking criminal action against you?
Now, what is my respectful submission? Pond is there. Only one portion of the pond is owned by
So
them.
let us assume you are right. You have title to the pond. Let me go to that extent. Please let me complete. That you are the rightful owner of the pond. Pond is there. You are the owner of the pond. Are you entitled to fill it up? Are you entitled to fill it up or not?
No, my
You are
lord,
not entitled.
I cannot.
Now, if there is an allegation made, before the district magistrate saying that you are filling up your own pond, will that not be taken into consideration by the district magistrate, or will it be taken into consideration by the
Subject
district
to
magistrate?
They make a representation. They make a representation because the one part of the pond is having the share of them. One part is pond.
Whatever, I am not going into that.
Balance
Again, you are diverting from the point that I am taking.
No,
Sir.
my lord. Balance three part.
Very well, then you take it up wherever you want to take.
It is
I think this, if you are not willing to answer the question of the court, you are going on in your own way. There is something which I am asking you. You are not willing to answer that.
Thing is that, if your lordship kindly see, their representation is that we are the users, and some of us
Show me the law.
owners of the plot. And due to filling of the pond, making a construction, we have been seriously prejudiced and as such fair to restore the pond its original position upon demolishing the construction made over there. With due respect, we would like to humbly submit the above casting person, Ansar Malik. Ansar Malik is my client, and others back the wrongdoers. Now, they are the relatives. But one party is taking steps by putting them that you are filling up the pond. They did not raise the they did not raise for the court below.
Not required. They have not raised it. That is a matter of title. Under the West Bengal Inland Fisheries Act, they are entitled to approach the competent authority. They have given an information. He will take action in terms of the information. How is the civil court going to prevent?
Now, in the court below thing is that they raise all the point. They raise all the point. Because we cannot fill up the pond, because that will create.
I will direct whoever is filling up the pond, the filling up of the pond should not be done. It should be restored if it is filled up. That direction I will.
Original character.
Very
to
well.
the original character.
Likhene.
Whoever.
This
instructions to appear on behalf of the private respondents. Lordship, I'm praying for a week's accommodation to take further instructions.
What is the matter? It's against the what happens against the bank? What is your matter, sir? Belongs to DT. Acha.
Now, why not what happened? My client, my agent, our education is taking 2000 well, that she completely go up to my right and appointed another one, another Shemite as a which is opposite to the ornament. And one Shemite already died.
No, but what will the writ court do in that? This is a civil matter.
What happens that is involved another one here, one of that make stop David or something. I'm sure I'm saying.
Yes, sir.
Yeah, I am for the respondent number 9.
Who is for the bank?
Mr. Devashish Shah is appearing on behalf of Respondent Bank, Lordship. I am praying for not this week because we are seeking instruction, Lordship.
The next Friday. लिखे नहीं? Learned advocate appearing.
Occasion and submitted the report. Submitted the report has been already covered and all the given according to prayer of the
Yes.
according to prayer of the
Yes, yes. Your grievance appears to have been redressed. Now they say that in terms of this. For what? Supplementary affidavit, how you can seek relief?
My lord, to address some other issue, my lord, my lord, letter is over or two. First, I am
Just a minute. Yes. देखिए दीदी सप्लीमेंट्री तो दिन सप्लीमेंट्री what do you want दीदी इसी चलिए दीदी So, but this prayer has to be first made before them that you want these benefits. How can the writ court suddenly direct them? You have got this. Very well, even if you have to check in the act, there has to be a prayer, a representation. How will a mandamus be issued immediately? You make that prayer before them, let them refuse it. No, but I fail to understand how will it serve the purpose? then also I will have to give you liberty to approach them only. I cannot simply direct them. A lot of things are there, accounts are there. It's a question of payment. How will I make payment to them? Whatever is there, that has to be, sir, that has to be factually checked. How can the writ court suddenly direct that make payment to them? Who else will come up saying that I am also the heir? Nobody knows that. I cannot direct that. Then may or may not be the issue. See, I cannot get into that aspect immediately by way of a writ petition. Even if you take an adjournment, you are on notice that on that day also the order that is going to be passed is only a liberty, nothing more than that. And that only if you are entitled to in law. I cannot declare everything here sitting. You take this writ, then supplementary, file it on that day. Not necessary. Serve them and then file it.
My lord, with the leave of my senior, may I
Yes.
say this, my lord? May I humbly say this? My
Yes.
lord, can you seize the there, my lord, prayer, my lord?
Yes.
At page 10 of the petition. My lord, the petitioner prays, the petitioner prays for, my lord, and the copy of the investigation report, and also a copy of the, my lord, presumed date certificate. Now, my lord, video ordered passed by your lordship, my lord. Petitioner has got this report and also the
right. He's right. Absolutely right.
Now, my lord,
why are you enlarging the scope of the
my learned senior, my lord, is expecting the compensation on which follows by the issuance of the certificate. That gives rise to a, my lord, separate cause of action, my lord.
Yes,
So by
he's
way of
right.
a
He's
supplementary
right.
affidavit, my lord, the scope of the writ petition, my lord, may not be enlarged.
That is difficult, sir. That is difficult. What will you try? Even if provision is available in the act in this writ petition, how can that order be passed? You cannot expect me to pass illegal orders. Whatever I want, I will do. That I can't do. I am bound by rules. I have my own limitations. I cannot transgress everything and pass orders. That I cannot do. Even if provisions of those acts are there, you have to follow the procedure. You cannot jump the procedure, come to writ court and get everything. This is a peculiar submission you are making. No, if provision is there any provision in law that even if there is a provision you have to approach the writ court, take leave and then apply? Where is that provision? You go and withdraw money from the bank using your check. Do you file a writ petition and take leave of the court? What kind of submission are you making, sir? Mr. Betal, whatever is there, you have to check it and apply. Why writ court is required? But why adjournment here? This writ petition has become infructuous now because he has supplied. Situation I have considered. Why you did not consider the situation when you made this prayer, sir? Why do you leave it on the writ court to consider everything? When you approach this court, when you frame the prayers, you frame prayers in a particular manner seeking certain things. When you get them, then you expect the writ court to become more benevolent, give you everything under the sun. That is not possible. We also have our limitations. We can't do that. I'm adjourning it, but I'm making it clear that I'll dismiss it on the next day if you press for anything else. This is not fair. Whatever it, now you have knowledge, you take steps. Whatever steps you have to take, you take steps.
My lord, there
in
was the
accordance with
averment,
law.
my lord, in the writ petition.
On this writ petition, nothing more can be done. an order, I will be doing exactly that which is prohibited. I say that in accordance with procedure established by law, and I trump that procedure. That's not what I should do by issuing a writ. Yes.
For the state,
You see, in view of the lordship's last order, we had informed the bank to pay. The bank has made an endeavor, and they have found something which required to be put it on record.
No, but I had said report in the form of an affidavit. Why is that affidavit not?
I have to disclose the reasons for.
To disclose it, why is
Yes.
it not in the form of affidavit?
No, because your lordship, the record pertains to 1986.
So what?
We found, your lordship, recently we have found, day before yesterday, we found that they took a loan, they made default, and thereafter he was indulged in some fraud. That is, I want to put it on affidavit because
that was the direction. That is exactly the direction.
Yes,
We pray for time then. Learned advocate, Mr. Singh, learned advocate appearing for the bank. Who is for the respondents? Serve a notice on them again. Serve a notice on them. You are appearing? So serve a notice on them. Serve a notice on the government leader's office. That will help. None appears for the respondents. Full stop.
My lord, my writ petition. This case, my lord, where I applied for water connection, my lord,
water
payment was approved.
My lord, but my lord, page 39, my lord, who made this application before your lordship, and my lord, who made an application for water connection? My lord, kindly, my lord, have a look. This company is separate. My lord, kindly, page 39. Who, my lord, files this petition before your lordship?
Yes.
Amrit Bali, my lord, this application Suraya Alloys Limited, my lord. Kindly have a look. We have done this work to this company, my lord. My report.
আমাকে দেবে না? হ্যাঁ?
Yes, sir. You
My
have
lord,
not
this-
made any payment.
The payment has been made, my lord. Your lord,
No, payment has been made by Surya Alloys, not Amritvani. And Surya Alloys say that you don't have any shareholding in Amritvani.
my lord, they are sister
Uh,
concerns in any event because this report is forthcoming now, my lord. He has handed me over in course of this hearing. If your lordship, my lord, kindly allows me a week's
Consider
time,
it and come back.
I'll come back, my lord, because this is something new which has come.
Liken it. Learned advocate appearing for he was there in the first half.
Yes,
saw him.
present. But due to his personal difficulty, he has left the court. So, Lordship, I am praying for adjournment.
Very well. Mr. Galib, he had on the last occasion
I
shared
have
certain
received
judgments.
those.
So you have a task.
No, I have already done my homework also because the judgment which my learned friend was relying upon, that was appealed against by the state and it was taken care of. And the very appeal order is the part and parcel of the bunch of document which I had handed over to your last occasion with a copy to my learned friend also.
Very
the
well.
part-
So let him come. Let him come. His personal difficulty.
No, certainly.
So when do
Great.
you want? Next Friday?
Yes.
5th?
Yes, Lordship. Grateful.
An adjournment is prayed for. বসে লিখুন না। Adjournment এর এত দাঁড়াতে হবে। An adjournment is prayed for on behalf of you are appearing in person.
हाँ सर आज टुडे मैंने আমাদের অ্যাডভোকেট সাহেব আজকে ফাইল যে কোনো কারণে রিটার্ন দিয়ে দিয়েছে अच्छा ठीक हिंदी में बात करें हमारे वकील से बांग्ला दे
No, no, you can speak in Hindi as well as Bengali, English, whatever you are comfortable with.
আমাদের উকিল সাহেব আজকে যে কোনো কারণে আমাদের ফাইলটা রিটার্ন দিয়ে দিয়েছে
নো অবজেকশন দিয়েছেন
নো
আমাদের
অবজেকশন দিয়ে দিয়েছেন
আপনি কি অন্য কোনো উকিল বাবু রাখতে চান?
না আমাদের
और
নিজেই দুটো কথা শুনে নেন যা করার
हैसियत नहीं है सर और
স্যার মোবাইল
ठीक है, बताइए क्या
স্যার
बात?
ওর মোবাইল অন করে ওতে মানে বিগ ভিডিও রেকর্ডিং আছে যেগুলো মানে এতে 3-4 মিনিট সময় লাগবে
सर आपने
কেসটা ক্লিয়ার হয়ে যাবে
सर आपने सुना होगा कि सेल रामनगर में गाड़ी चलती थी, लिस्ट ऑफ स्टूडेंट्स की रिक्वायरमेंट थी मेरी, तो उन्होंने नहीं दी, तो मैं बिना लिस्ट के 40-45 स्टूडेंट्स कैरी कर रही थी 15 सीटर गाड़ी में। तो सर ने मिसबिहेव किया और कहते हैं कि लिस्ट नहीं दूंगा, आपको चलाना होगा। बहुत मेरे साथ मिसबिहेव किया उन्होंने। और मैं एक विडो हूँ, 20 इयर्स 25 से कॉन्ट्रैक्ट चल रहा है मेरा सेल में। हस्बैंड 25 इयर्स से 20 इयर्स से मेरे हस्बैंड चले गए, तो मैं वो कॉन्ट्रैक्ट चला रही हूँ विथ ईच एंड एवरी पेपर ओके, ईच एंड एवरी डॉक्यूमेंट ओके। बस इस बार उन्होंने लिस्ट मेरे को नहीं दी है।
मैम आप नरेंद्र कौर हैं?
हाँ जी सर, मेरी रोजी रोटी यही चल रही थी 25 साल से।
Why are you not providing the documents?
First, there is a
Oh, sir, that
is the technical part. Not
Where is the NIT?
19.
No, even if there is no clause in the NIT and you don't provide them the list, then in that case, is that not something which will make the contract itself unworkable?
Yes, sir.
Why not? Suppose you have employed the person concerned, entered into a contract saying that you have to lift certain school children from one place, take them to other, transportation of school children from one place to another. The school says designated or the place is designated. Nobody knows who the children are. Now the allegation here is somebody comes and barges into the bus or whatever vehicle it is. If you supply the list of students, what is the harm? I don't understand. Why this fight in I will not supply list of
Because
students?
sir, they don't have any list of students. Last 2 years also I faced the same problem. And here's the list of 40-45 students I have.
Please wait. Please take your seat.
Okay, sir.
Take the mic.
Just there is a clause, being clause 8 of the special terms and conditions, saying they have to check the I-card. That clause is there. I-card of the students, which we provide to the students. They have to check that. That is the technical aspect of the and on merits.
No, the I-card means what? The I-card will
identity card, letter of permission of each student boarding the bus, and shall allow only
I-card will be with the student.
Yes. And shall
Madam, agar I-card hai, to fir what is the problem?
They don't have I-card. They did not give
saying
me
they
any
have.
list. No, never. They don't have list.
Just this point has become there is no point.
No,
in
no,
fighting it
no.
Because
you cannot deny.
Kindly take
Last 2 years,
Please
the
wait,
same
madam,
thing
please-
happened, sir.
Please wait, madam. Please.
Kindly takes the work order at page 84. This work order is dated 18 November 2023. And if my lord sees point number 13,
Point?
point number 13, the validity period is 530 working days, which
Yes.
is over. The work order period of work is over during November, end of November 2025.
So why did you not produce the list to me?
The period of work is over.
So the contract is no longer subsisting.
She's not working. The period is
How
already
can I
over,
work
ma'am.
without list of students?
Final point number, and also
Madam, I'll call upon you. Please take your seat. Ab baithiye. Please take your seat. Let him conclude.
And if my lord kindly sees the below this 18 points, Roman point 1, the date of commencement of work shall be recorded from the actual date of commencement of work or 10th day from date of issue of work order, which is early. So 530 working days is over. The period of the work order is over.
Yes, madam. Contract is not there anymore.
सर 2 साल से मैंने लिस्ट का डिमांड किया है, 2 साल पहले भी इस रूट में इश्यूज थे, आईआर इश्यूज थे, तो तब भी
नहीं देखिए, कोर्ट में जब आए तो कुछ रूल फॉलो करना होगा। आपका जो कॉन्ट्रैक्ट था वो 530 दिन के लिए था।
सर 1 साल से मैंने केस यहाँ पर फाइल किया हुआ है, तो आज मेरे को डेट मिली है सर, इसमें मेरा
नहीं डेट तो इससे पहले भी आई थी। 21 नवंबर दिस केस वाज टेकन अप, जब एडजॉर्नमेंट मांगा गया आपकी तरफ से। दैट इज द ऑर्डर।
हाँ
Also,
हाँ तो बोल।
if my lord kindly sees,
इस पीरियड के अंदर में ये सर ये लड़ाई करते करते बीच में एक्सपायर हो गया ना
530 डेज।
हाँ तो लेकिन अब क्या किया जा सकता है?
नहीं सर, 2 साल से मैं दौड़ रही हूँ लिस्ट के लिए, इन्होंने मेरी गाड़ी बंद कर दी। मैं पुलिस स्टेशन में विद 40-50 स्टूडेंट्स और 50 गार्जियन को मैं फेस करती रही अकेले, लेकिन इनके सर और ऑफिसर नहीं आए देखने के लिए, अकेले मैं फेस करती रही। डेली सुबह 30 स्टूडेंट्स लेके जाती हूँ, शाम को 40 आ जाते हैं।
तो भी तो
और
आप,
आईआर इश्यूज हैं,
आपकी
वहाँ पे
केस
4-4 पार्टीज हैं रामनगर में।
आपकी केस फाइल हुई 11 फरवरी 2025।
हाँ जी सर।
आपका कॉन्ट्रैक्ट 2023 का है ना?
530 डेज का।
हाँ लेकिन 2023 का कॉन्ट्रैक्ट है ना, 3 अगस्त 2023।
वो 530 डेज व्हेनेवर कंप्लीट होंगे तब।
2023 से 2025 फरवरी में आपने केस फाइल की है। 2023 से 25 तक बीच में आपने क्यों नहीं केस फाइल किया?
क्योंकि सर मेरा पैर फ्रैक्चर था, इन्होंने मेल डाला मैंने दिल्ली में।
देखिए अब चूंकि कॉन्ट्रैक्ट खत्म हो गया है तो रिट कोर्ट वापस कॉन्ट्रैक्ट तो रिन्यू नहीं कर सकता।
लेकिन सर मेरे को इंसाफ चाहिए, मेरे को इंसाफ चाहिए।
डैमेजेस और कॉम्पेंसेशन के लिए
हाँ जी सर,
ये कोर्ट उचित कोर्ट नहीं है। डैमेजेस और कॉम्पेंसेशन के लिए आपको सूट फाइल करना होगा, जिसके लिए जब मैं ये केस खत्म करूंगा अभी तो लिबर्टी दे दूंगा। यू फाइल सूट or compensation and claiming damages. That liberty I will give you because that cannot be decided here. आपको डैमेज हुआ है या नहीं हुआ है, that will require evidence. वो एविडेंस के आधार पे वो तय होगा, वो ये कोर्ट तय नहीं करेगी, वो सिविल कोर्ट उसके लिए बना हुआ है। आपको दीवानी की केस करनी होगी। I will give that liberty to you. You file it.
हर दिन सर मैं नई मौत मरी हूँ।
ठीक, इसको दिखाइएगा, वहां नीचे दिखाइए।
हर दिन नई मौत मरी हूँ, कोई इनके ऑफिसर नहीं आए। मैं 50-50 बच्चे और 50 गार्जियन को अकेली फेस करती रही। इनके ऑफिसर बोल रहे हैं गेट आउट ऑफ द रूम, गेट आउट ऑफ द रूम। आई डोंट हैव स्टूडेंट लिस्ट, यू हैव टू कैरी
के लिए आप कहीं और मुकदमा कर सकते हैं।
क्योंकि जॉब स्टार्ट भी किया, लिस्ट
receipt
डिमांड
भी
कर
है।
करके हम हार गए सर। ऑफिसर नहीं आए, कोई सामने रिसीविंग कॉपी सब मेरे पेपर डॉक्यूमेंट।
रिसीविंग कॉपी है।
एक महीना मैंने 45 स्टूडेंट्स कैरी किए 15 सीटर गाड़ी में।
उसमें मैंने ऑब्जर्व किया कि यू आर फ्री टू इनिशिएट
एक एक
लीगल
डॉक्यूमेंट
प्रोसीडिंग्स।
सर मेरे सब सही है एकदम।
चल नेक्स्ट।
Also, I appearing for the WSC.
थैंक यू।
Thank you. The last week also petitioner was not there, madam.
No, petitioner was there.
No one. Or
9th of September. ऐसे
on
लिखे नहीं।
21st September, 21st November.
None appears for the petitioner. No accommodation is paid.
Not respondent number 3.
Respondent number 2 and
No, this is with
Forest
regard.
authorities are there or not?
আমাকে একটা দিও তো। কত 300
Yes.
But I do not have any copy of this report.
This report says that it can't be cut, but that is not the requirement. We don't want the tree to be cut. We want it to be secured so that it doesn't cause damage to the residential premise of the petitioner.
Now, my lord, your
What
lordship
is the-
kindly see section 327 of the, my lord, the West Bengal Municipal Act.
I don't have it.
My lord, your lordship kindly see 327. I'm sorry, my lord. This 327, my lord. This can be done by the municipality itself.
This is not a structure. This is a tree.
No, my lord, they kindly see the entire section.
Yes.
Yeah, my lord, can.
This is about structure.
My lord, can.
Tree is not a structure.
No, but
This
my
will
lord,
not come within the purview of tree. Structure is something which is man-made. This will not apply.
My lord, these are
your lordship
consumption parts.
kindly see. দাঁড়া আমাকে বলতে দিন প্লিজ ইট ইজ আমার মাই পিটিশন তো প্লিজ লেট মি but kindly comes to page 85. First of all, my lord, page 82.
Page 82.
Yes, my lord, kindly see an order was passed in which, my lord, the page 84, the police has, my lord, submitted a report.
Page 84.
Yes. My lord, kindly see page 84. My lord, this is the report submitted by the police authority in pursuance of the order.
Page?
page 84 of the writ application, my lord.
Page 84 of the writ application.
Yes, my lord, that is the report. My lord, kindly see, may I place this report with due respect?
You have placed it, I have read it.
Yes, my lord, the last, my lord, the OP member is having a coconut tree within the parameter of his premises, but this above said coconut tree is hanging and increase in height by falling in the sky into petitioner's property, and it is damaging the property of the petitioner.
See, forest authorities, I think, have little to do in this. Now, this appears to be more in the domain of the private respondent. He has to take whatever action he can take so as to prevent the tree from damaging your property.
Yes, my lord, my only submission is that my property should not be damaged. If we can take steps, my lord, then.
My lord, at first, my submission is the construction, the structure is illegal structure according to municipality, my lord. Then, if
my lord, why he is saying municipality, I do not know. This is the plan.
My lord,
I have got the plan.
There is an order, my lord. There is I have given, my lord, a specific. My lord, there is an enactment, and section 7 of the enactment reveals that there is a provision for appeal, my lord. They go beyond the, my lord, beyond law.
I didn't get your point.
My lord, according to, as for instance, if there is an illegal construction, then we should to go through municipal building rules.
Illegal construction or not, that is not for you to decide. That is
Yes.
decided by the municipality upon a complaint being made.
And my lord, several allegations has been, I have
As
annexed.
now, that is not the question.
Yes.
The question is, how is the structure to be secured without harming the tree in question?
Yes, my lord, that is the only thing.
My lord, there is.
My lord, your lordship kindly see section 328, my lord.
It reveals in the photograph, my lord, there is a rope, for securing the same. I have applied a rope, my lord.
Mr. Chaudhary, this is more in the nature of a private complaint. What will the authorities do here? Somebody's trees is falling.
No, my lord, kindly
has
see
leaned into your
328, my
property.
lord, section 328, my lord, kindly see.
328 of?
Yes, 320 of the West Bengal Municipal Act, kindly
Yes.
see.
328.
If any tree or any branch of a tree or the fruit of any one of the tree overhangs or is likely to fall and thereby endanger any person or any structure, well, or
So you make an application in this provision before the chairman.
that application, my lord, kindly see how many applications are there, my lord. I
will
have
direct the
annexed all
chairman to
this.
take
Yes,
action.
from the very beginning, my lord, no answer.
Yes.
My lord, no answer from the municipal authority. My lord, kindly turns to first page, my lord, page 70, my lord, page 70. That was the first letter of my from my behalf to my lord, the neighbor, and then, my lord, kindly see page 72, P5, Commissioner of Srirampur Municipality. Then, my lord, page 73.
Commissioner or chairman has to be chairman.
Yes, my lord, that is also there. My lord, kindly see page 74.
Yes, sir. Why has action
Series
not
of
been taken?
letters.
Who is appearing for
No
the
reply.
Page 96.
The forest department has already been taken action.
Forest department is not going to act. It is under your domain. You have read section 328.
Yes, well, but
Then
the report is not annexed here because the report is sent to the petitioner only.
whose report? What report?
Yes, well, it is kindly from page 96. Well,
Page 96.
it is from the divisional forest officer Howrah division.
What action have you taken? It is your responsibility or municipality.
Because the forest department not send a letter.
Forest department is not to act. You are supposed to act. What will forest department do here? It is his personal tree.
This is
Then, so therefore, forest department has no role to play.
But if, my lord, go through section 5 of the said act, my lord, which I have given, my lord.
Section 5 of what?
Section 5 of the said act, my lord.
Yes, section 5. This is a different permission to fell trees.
Permission to fell trees.
Not required. You will not take permission to fell your own tree. That is quite understood. But by not requiring permission to fell your own tree, you will allow your tree to barge into someone else's house and damage the property. That also can. Why don't you secure it? You tie it with a rope so that it doesn't harm the property. It's harming his property.
But property is not legal.
Very well. That will have to be decided by the municipality in terms of section 328. Why are you not taking action on that? if you feel that you are not able to take action, then in that case, come up, say that you don't have any authority to take action.
My
But
lord,
it
even
doesn't appear
kindly
so.
see page 92 also, page 92, 12/12/2022,
Section
another
328 enjoins you to take action. It contemplates action by the municipality.
page 92, my lord, another letter was written, no reply, not a single, my lord, reply was made by them.
Likhe nahi. You please act on this in terms of 328. Give both of them a hearing and take a decision. হ্যাঁ দিদি কল করুন।
38, Your Lordship, I am appearing for the petitioner. The instant matter is pertaining to non-payment of compensation by the Indian Railway for taking of land for Deshpran Nondigram Railway project, Your Lordship. Here is my affidavit of service.
Nobody appears.
Last day also nobody appeared, Your Lordship.
That was in June 2025, not now. So there has been a change of determination there.
No, after changing the determination, Your Lordship, the matter appeared and Your Lordship directed to file
Not
me a
before me, there is no order.
Your Lordship directed me to file a CAN application, Your Lordship, that has already been filed also.
There is no order. I have never taken this matter up. That was before the other honorable judge, not before me. What is CAN for?
Huh? What is the CAN is for adding party, Your Lordship.
CAN is not in file. CAN is not in file also.
CAN is, but the CAN has been filed, Your Lordship.
Didi, CAN
in the cause list also it is showing that there is a CAN application, Your Lordship.
It is not in my file.
Oh, yes, Your Lordship. That may be.
Didi, CAN ta file ana nahi. CAN ta file ana. It may have been filed in the court where it was.
Oh, okay.
So it is lying there. Niye nahi? CAN 1. Likhe nahi. CAN 1 of 2025.
No, that is affidavit of service.
Affidavit of service filed today be kept with the records. Full stop.
The last paragraph.
Likhe nahi.
I'm handing over a copy of the
Appearing only in you are appearing in the next matter also?
No, no.
ওদের অ্যাপিয়ারেন্স দিয়েছে? আচ্ছা, এইটাতে স্টেট ইজ নট রিপ্রেজেন্টেড, শুধু এই আগেরটা শুধু লিখবেন, কারণ অ্যাডভোকেট অ্যাপিয়ারিং ফর দি পিটিশনার সাবমিটস আর তো অ্যাডভার্স কিছু পাস করতে পারবো না, 3:30 বাজে। এমনি কল করে দিন, যদি বোধ পক্ষ থাকে তাহলে করে নেব। Yes, Mr.
So, madam, can it be taken Friday week, because next Friday I will be out of station?
আচ্ছা, লিখে দিন, লিখে নিন।
Madam, may I file a supplementary affidavit or should I file it on the next date? I am filing a supplementary. We will definitely.
No, it has been served. Liken in, Mr. Why supplementary was required, Mr. Singh?
Madam, we had certain documents collected on the basis of Right to Information Act, which we could not incorporate earlier.
Very well. Mr. Singh, learned senior advocate appearing for the petitioner, seeks leave of this court to use a supplementary affidavit. Full stop. Let that supplementary affidavit seeks leave na kore, seeks leave to file a supplementary affidavit that has been prepared in order to bring on record certain documents which the writ petitioner has received subsequent to the filing of the writ petition.
Subsequent filing.
Yes. Has
On the
received
basis of Right to
subsequent to the
Information
filing of the writ petition. Full stop. Such leave is granted. The supplementary affidavit filed today is taken on record. Full stop. Copy of the supplementary affidavit.
We have already served everybody. We'll prepare a affidavit of service.
Copies of the supplementary affidavit have already been served. That copies of the supplementary affidavits have already been served upon the respondents. Full stop. As prayed for, list this matter for
12th.
When? After 15th, he's saying.
But no issues, madam.
As prayed for, list this matter once again on 19th. December 19th, 2025.
Madam, so grateful. আমাদের অ্যাটেন্ডেন্সটা দিচ্ছে।
44 কি হলো? Yes, Mr. Hussain. Yes, 44.
My lord, I am appearing for this state. My learned junior is.
But I am praying for accommodation for the day, my lord.
Not today.
Yes. Yes.
If both parties are there, I can take up. Otherwise,
My lord, I'm appearing for this state. My lord, my learned junior is having instruction. Also, it is regarding ECL property, because matter relating to ECL, their quarters have been preoccupied by another person.
Petitioner has prayed for time, madam. Petitioner has prayed for time. I have made it not today. Next.
Yes.
But the state is not appearing. Private
Not today. Not today.
Ordinary Lordship, I'm for the petitioner. Lordship,
I'm for the West Bengal Pollution Control.
Lordship, that's to give some instruction for the state. But
State is the answering respondent.
answering is from
Not today.
Lordship, there is also similar order passed by the Honorable Justice.
Very well, they have to be here.
Yes.
Respondent number 8.
Friday, Lordship. Yes.
But I'm looking for the
Not today.
respondent number 8 in this matter, Lordship.
চলুন কল করে দিন, ছেড়ে দিন, ছেড়ে দিন, কেউ নেই, লাভ নেই।
350. In item 350, I'm led by Ms. Rashmi Singhi. The matter may be allowed on Monday, my lord.
Monday, no, it will be again on Friday, specially assigned matters on Friday. এই ফালতু লাভ নেই তো, আজকে তো 3:30 আছে তো, কেউ নেই যখন আর কি করবো। থ্যাংক ইউ।